Good afternoon. Welcome to the Appellate Division First Department. As I call the calendar today, please ask for the time you actually need. And remember, if the panel has additional questions past the time you've been allotted, we'll ask them and you'll have a chance to answer. We have read your papers, and we are familiar with the issues that underlie your appeals. For those of you here for the first time, you should know that the white light on the lectern will go off when you have 2 minutes left, or if you've asked for less than 2 minutes, it will go on immediately. When I call your case, rise and let me know who you represent and how much time you are requesting. People v. Tyriek Anderson. Submitted. Diaz v. Roto Elevator.
Appellate Mayor Estates.
How much time? I'm sorry, counsel?
10 minutes.
Do you want time for rebuttal?
Time for rebuttal. 5 minutes for rebuttal. Like you requested 15 minutes.
Okay, thank you. No, this is Diaz v. Roto Valley Elevator. We'll get to Boston. Thank you. I was wondering who you represented.
It's a new party.
All right, 4 and 2 and 4. C. Edwin. Four and 2 and 4. Maza v. 120 East, 144th Street. 4 and 2 and 4. Iuso v. State of New York.
Appellate, and Your Honor, you're also on Al-Shami. Those are kind of joint cases. I would do 10 and 5 or 8 and 4.
Okay, so we'll hear them both together, though there are some distinct issues, obviously. We'll go with 6 and 2 and 6.
Yes, sir.
People v. Rolando Calderon. Submitted. Prosite Specialty Management v. Altruist.
Appellate 7 and 3, Your Honor. Respondent 5, Your Honor.
6 and 2 and 5. U.S. Bank v. Chait. You don't appear to have an opponent. You still wish to address the court? 2 minutes, it is. People v. Matthew Nicholas. Submitted. Perez v. Tanya Towers. Four and 1 and 4. People v. Terrell Williams. Submitted. Sanchez Rodriguez v. Bruce. Fantastic. I'll give you, you want some time for rebuttal too? All right, I'll give you 4 and 2, 4, and then if you hear anything and you do wish to speak, counsel, you may, but I agree with you. It seems like it's prudent not to. Thank you. Diaz v. Boston Properties. 4 and 2 and 4. We're going to take that one first. Taylor v. City of New York. Okay, we'll go with 4 and 2 and 3 and 3. Iuso v. King. 4 and 1 and 3. People v. Roderick Smith. Submitted. Tapanakis v. Pace University. Oh, okay. Give you 4 and 1 and 4. Ward v. Northeast Truck Rental is submitted. First case up is not Diaz v. Roto, but rather Diaz v. Boston Properties. Give me a moment, counsel. Please.
May it please the court. Good afternoon. Christina Mercado with Block, O'Toole and Murphy for plaintiff appellant Salvador Diaz. The lower court here erred in dismissing plaintiff's labor law 240 claim and should have granted plaintiff summary judgment on this claim because the unsecured ladder failed to remain steady and erect during plaintiff's overhead welding work. The record in this case includes the accident report admission on page 886 of the record that what caused the accident was, quote, ladder moved while employee was working.
Now, you can see that the ladder was not defective. The surface was flat. There's no evidence to the contrary.
That's correct, but that doesn't matter under many of the cases from this court, including Lynn, the 2021 case, in which this court distinguished the very 4 cases that the lower court and the defendant respondents rely on in this case, and that's Antonucci, Mitchell, Ellerby, Buckley, all of which involved admissible evidence that plaintiff missed a step or lost his footing while descending or climbing up a ladder that actually was secured or was proper for the work. In this case, we have unrebutted expert evidence that the A-frame ladder, an 8-foot A-frame ladder, was inadequate for this overhead welding work that was 10 to 12 feet high. And
What
that,
about is there contrary competent evidence that, in the medical record, that there was a different cause of the accident?
the single
That he was
page-
descending the ladder, not using the ladder at the higher rungs?
That's based on a single page printout that is not certified. It's inadmissible and it's the only thing submitted. So therefore it can't defeat summary judgment under, again, many cases, but we've cited Brito from this court on February 5th of this year. And it was the same thing. It was a single page printout that said plaintiff missed a step as he was climbing down the ladder. In this case, plaintiff specifically states that he was welding, not climbing down. Page 440 of the record, his coworker specifically states that plaintiff was welding and not climbing down the ladder at the time of the accident. He wasn't moving at all, page 823 of the record. He was never coming down. He was standing there welding.
And it's, counsel, it's undisputed that the ladder did shake, right?
And it is undisputed that the ladder did move. And in this,
That would distinguish it from a case where the ladder stood
That's
and it
correct.
was just a matter of the person falling.
That's correct. The ladder moved. It fell to the floor, page 893 of the record.
Counsel, there was also a coworker present. What is our decisions regarding coworkers being present?
Well, that if you're referring to that a coworker is not a safety device, that's true. In addition, this coworker could not have even held the ladder because it was welding work. And the coworker is a fire watch. It's his job to stand 6 feet away and watch for fire because there's actually sparks. Welding is, you're using fire and actual sparks are flying down. So he can't stand there and hold a ladder, which is why a Baker scaffold or a lift of some kind was required. And this court held in Plywash and other cases cited that it's irrelevant whether plaintiff initially lost his balance before or after the ladder wobbled, because under either scenario, the ladder failed to remain steady under plaintiff's weight as he performed his work, which is exactly what happened in this case. And if the court,
It seems like the Brito decision that was issued this past February is pretty much on point.
correct. It's a single page printout. It's inadmissible. It doesn't raise an issue of fact.
Well, it could be that statement made, and we're not sure how it was made and who made it to whom, but it's not necessary for diagnosis and treatment.
Correct.
It wouldn't be meaningful at all.
Correct.
Thank you, counsel. You have time to rebuttal.
Thank you.
Please.
May it please the court, good afternoon. John Colrefi for
You could
respondents.
move that mic up a little bit. It might be easier. We'd hear you better. Thank you.
Thank you. I would just like to address 2 points for respondents brought up in appellant's reply papers. First, I would like to distinguish the White and Plywetz cases. In the White case, that involves a ladder that was moving while the plaintiff jumped off to avoid the fall.
Right,
Here-
there was an adjacent case that he jumped from there or moved from there to the ladder, in the White case.
In the White case. I'm sorry, my case is mixed up. For the Plywetz case, I'd like to say that involved a failure of a suction cup, which caused the plaintiff to lose his balance. Here, there was no such failure of a safety device.
Well, the ladder didn't hold, right? The ladder shook.
Oh, well, the plaintiff himself testified that the ladder shook due to his loss of balance.
Does it matter why it shook?
I believe.
The ladder shakes, it's not being used, it's not being secured, right?
The plaintiff.
The ladder shakes, it's not secured. I think that's straightforward, right?
Right.
I mean, I think that that's what we were saying in the Plywetz case is under whatever scenario, whether the plaintiff initially lost his balance or the ladder wobbled afterwards, the thing is, if as Judge Scarpula just said, under either scenario, the ladder failed to remain steady under the plaintiff's weight. And that's really what the cases are looking at over and over again, I think.
I would just submit that I believe this is more similar to the Mitchell, Antonucci, and Ellerby cases where the plaintiff falls from an otherwise secured ladder without more. And the second point I would just like to
What
address-
would have made this ladder otherwise secure? What in the record suggests that it was otherwise secure?
I would point to the plaintiff's own testimony where he stated there was nothing defective with the ladder, there was no debris or wetness in the area, and that he positioned himself the ladder, and that the ladder was properly positioned before beginning work.
But there's a
We agree, I'm sorry, go ahead.
Go
Ken.
ahead, I'm sorry.
We agree that being not defective isn't the same thing as being secured, right? You can have a perfectly good ladder that isn't secured, and that's what you need to do to comply with your 240 sub 1 obligation, is to make sure that it remains secured.
I would just point to, again, to the Mitchell and Antonucci and Ellerby cases that state that not all falls from a ladder fall under two.
Totally agree. If the ladder hadn't shook and it stood steady, and the only thing we had was a plaintiff jumping off, that would be one thing. But that's not what we have here. We have a shaking ladder.
Due to the plaintiff's loss of balance. Yeah. If I may, I would just address one more point, the point of the accident.
Counsel, again, the microphone closer.
Sure, yes. I would just bring up, in rebuttal to the appellant's point about the accident report, that the accident report is a summarization of the plaintiff's supervisor who is not present and that would not supersede the plaintiff's own sworn testimony regarding the cause of the accident due to his loss of balance.
Anything else you'd like to add?
No, Your Honors.
Thank you.
The only thing I'd say is that, this court is absolutely correct. If the ladder moves, that is 240, and it's not that it doesn't matter at all what caused it to move. It's that here it was from the work he was doing. This isn't some unforeseen superseding cause of something, striking the ladder that was uninvolved in the work. So I just wanted to make sure that was clear. The accident report is an admission, so it's admissible. And if there's no further questions, I will rest on the briefs. Thank you.
Thank you, counsel. Thank you both. Diaz v. Rotovale Elevator. Please.
Good afternoon, Your Honors. Christina Pingaro for Appellate Mayo Estates here. This honorable court must reverse the trial court's denial of Maori's motion for summary judgment, which sought contractual indemnification from Rotovelli here. The reason is because Maori established its prima facie entitlement to this claim on summary judgment, and Rotovelli failed to raise a triable issue of material fact sufficient to defeat same, Your Honor.
No, it's undisputed, just to get one thing out of the way, it's undisputed that Rotovelli was the only servicer of elevators at this building, right?
Correct, Your Honor. And because they were the only elevator servicer in this building, it was squarely their duty and responsibility to maintain, service, repair, and emergently address any issues with the elevator.
And misleveling of an elevator is kind of like 101 problems that elevators have, right?
Your Honor is exactly right. It is something that actually occurs over time as an elevator moves, because it is a result of the cables moving through the sheaves which hold the cables in place, and the sheaves wear down over time through movement of the cables, and that causes a loss of friction between the cables and the sheaves. So any operating elevator over time will develop and persistently develop, in fact, misleveling.
Counsel, would you agree that the agreement between Maori and the elevator company, particularly at 660 and 661 of the record, I think subdivision or provision 11, discusses obligations of Maori? So since you were seeking summary judgment for contractual indemnification on this record, that means you have to have clean hands throughout. And it's clear from, for example, the invoices in May of that 12/12 that year, which identifies a Ms. Glick as your point person, who had an obligation contractually to communicate problems to Rotovelli. So my point is on this record, is it as clean as you think it is?
I'll address your Honor's questions in two parts. First, with regard to paragraph 11, though it does impose obligations on Maori, the obligations are very specific, and it is appellant's position that those obligations are two. First, that it maintain the elevator equipment in the machine room in a clean and orderly fashion, and that it protect it from the elements to prevent things like water damage that would affect the equipment or machinery in those rooms. And the second obligation it imposes upon Mayor is to, if identified, alert Rotovelli of problems with that equipment in the machine rooms.
So in this case, your witness did not seem to indicate when she was questioned that there was a protocol in place at the building for if someone complained about something, who would they go to? Would they tell this person? Would they tell that person? The plaintiff said she told someone at the desk. So it seemed a little confusing, and that's why it seemed like it might be hard to figure out if you could have established at this point complete freedom from negligence.
Sure, Your Honor, and I'll address that point certainly as well. In the cases that even if the court believes that there was an affirmative duty on behalf of Maori to address any and all issues that arose with the elevator, the car, the compartment, the doors, the buttons, the lights, any of these things, that this question isn't necessary to answer in order to come to the conclusion that Maori was not negligent here, as there was no... even if there was a duty, right, to notify, there is absolutely no evidence on this record of a breach of that duty or that such a breach causally caused plaintiff's injuries here. There is actually almost absolutely no way, there is absolutely no way to establish either of those two essential elements on this record.
Thank you, counsel. You have time to rebuttal.
Good afternoon, Your Honors. May it please the court. My name is Michelle Rosenblatt, and I represent the defendant respondent for Rotovelli Elevator. The motion court did not err in denying Mayor's summary judgment on its cross-claims against Rotovelli. Mayor and Rotovelli did not enter into a full-service maintenance contract. As Your Honor, you were saying,
But it's not disputed that Rotovelli was there on May 7th, right?
We were
Dealing
there,
with the
yeah.
misleveling issue, among other issues.
So we were there on May 1st, and the work ticket had indicated a dirty tape unit. And so our witness had testified that yes, a dirty tape unit could mean a misleveling of an elevator, but the way the work ticket was written, he knew that it wasn't a misleveling issue. And regardless,
That it was or was not a
it was
misleading?
not. And regardless, that issue was resolved.
That was the testimony?
Yeah,
from that
if
witness?
you look back at his testimony, he said, because otherwise, if it was a misleveling issue, it would have actually said misleveling on that work ticket.
But doesn't that confirm the language of the indemnification clause that this misleveling injury arose from the work of Rotovelli?
I mean, I disagree because, again, he said that there's no evidence that on that day there was a misleveling issue, because if there had been a misleveling issue, there would have been an indication. It would have said, like, misleveling on that work ticket. And he said whatever that issue was, it was resolved, and there's no evidence that that dirty tape still existed on the day of the accident. And I'll just argue that Mayor hasn't shown us free from negligence. Like paragraph 11 of the maintenance contract says, if there's any irregularity, if there's any problem with the elevator, Mayor has to shut the equipment down. They have to notify Rotovelli. Plaintiff testified that she was experiencing the elevator misleveling several times a month before this accident. She reports to some kind of gentleman who works.
So can I interrupt you for a second? So that testimony in and itself raises, if it was misleveling, it would, the only obligation of the owner is to notify you. And that's a question. But any issue with respect to the elevator is on you. So for you to say there's zero evidence that the elevator misleveled because of something that Rotovelli did is, I think, not right. There's the plaintiff's testimony, for example. There's all of the in pretty close proximity tickets showing that you are trying to fix this problem. And if it's anybody's problem, it has to be yours. It's nobody, I mean, maybe nobody's negligent, but if someone's negligent, it has to be you with respect to the elevator misleveling.
I mean, like I said, yes, I don't deny we were there on May 1st, on May 7th, but
And
as
the
our
plaintiff
witness,
testifies that this is happening all the time.
and then Mayor was supposed to shut down the equipment. They're supposed to report
That's
it
a
to us.
separate question. You're saying there's zero evidence that it could have been caused by Rotovelli's actions or inactions. I'm saying there is.
There was no misleveling on that May 1st incident.
But there was on May 7th.
According to testimony, there wasn't.
Yeah, but your work ticket on 769 at the record, it says, help Neil with car number 5. It kept going into dry fault and sitting above the floor about 6 inches. That's like misleveling to me.
Yeah, I mean, look, our witness thoroughly explained everything that was on those work tickets, like the descriptions, and he said none of it had to do with misleveling. Again, of course, I'm not an elevator mechanic, so we have to just rely on the testimony. But I'll rest on further on my papers. So.
Thank you, counsel.
Thank you.
Just 2 quick points on rebuttal, Your Honors. First,
So I want to, may I interrupt you just a second and say there is plenty of evidence that you had the obligation and didn't notify the elevator. I mean, I don't know whether it's true, but the plaintiff says that. And so I don't think that you can say as a matter of law that you can show that you are free from negligence. And while you might be entitled to conditional indemnification, I think there's enough, are you saying there's nothing in the evidence, nothing presented?
Your Honor, there is a single piece of evidence in the entire record about a single complaint.
One piece of evidence
You're
definitely
absolutely
is
right, Your
enough,
Honor. I'm not disagreeing with you. It was a complaint made by the plaintiff to an unidentified person at the front desk. Her testimony is that it was made about a month prior to the incident that she had. Between that time and the date of the incident, Rotovelli was on site over a dozen times for several hours. They were physically present in the building on the date of plaintiff's incident and in the week, six out of 8 days of the week leading up to it. They were present in the building on more than a dozen occasions in the month of August before the accident occurred. And so in the event that there is There was notice to an unidentified individual.
You have an obligation. What did you put in to show that you complied with your obligation to notify? Did you put in evidence of your practice and procedure?
So it is the appellant's position that there is no duty to notify Rotovelli here of everything that goes wrong with the
assuming that we
elevator.
disagree with you and say that the contract says that.
Sure.
What did you put in to show your practice and procedure, that you followed your practice and procedure? Because certainly you're not going to rely on the person who testified, because that person had no idea.
No, but to that effect, Your Honor.
Did you
Mr.
put in any
Para-
records?
We did, in fact, Your Honor. We submitted, appellant submitted the records of Rotovelli itself, the records from Mr. Glick, who had made the phone calls, each prior instance of misleveling with the elevator directly to Rotovelli, the records that demonstrated Rotovelli had responded to those requests, and the log books from the security who manned the front desk 24 hours a day, indicating that each prior incident of misleveling had been reported to and responded to by Rotovelli. So not only is there evidence that, yes, there was prior misleveling, yes, Maori, of those instances that it was aware, it advised Rotovelli, who then came and fixed the problem. And as Mr. Perez states on page 528 of the record, he actually explicitly states that misleveling is something that would be both identified and addressed during the monthly service.
So then the plaintiff's testimony, I guess, raises an issue of fact, because she says, I told him. And he says, no, she didn't, right?
No, Your Honor, with respect, even if the plaintiff says, I told someone at the front desk a month before my August 27th accident, Rotovelli was on more than notice after that date in the month of August for any
I'm not talking
issues.
about Rotovelli. I'm talking about your obligation to, under the contract, right? If we assume that you have an obligation to, every time there's a complaint, to call Rotovelli, and we have the plaintiff saying, on a month ago, I said this, and there's no evidence of it, and Ms. Glick says there's no protocol, and she never ever received a complaint about the elevator misleveling, that might raise an issue of fact, don't you think?
Respectfully, Your Honor, the final argument that we would make is that even if, assuming everything Your Honor has just said is true, the Rotovelli cannot make out any evidence of causation between the alleged failure to notify Rotovelli and plaintiff's incident, as Rotovelli was essentially omnipresent on the presence throughout the time between her complaint and the incident. If there are no further questions, thank you, Your Honors.
Thank you, counsel. In the matter of Edwin C. Please.
May it please the court, the Legal Aid Society by Hannah Kaplan for appellant. The family court erred in this case in entering a temporary order of protection against my teenage client, which entered into the domestic violence registry.
No, so the TOP has expired.
That's correct.
So there's a mootness argument, and you have an argument about evading review.
That is correct. I would submit that in my papers, I acknowledge that the issue is moot in that the order has been vacated and expunged. That being said, there is a clear issue in the record that the family court judge lets this go unaddressed. The counsel raises her objection to the...
Well, according to the record, the judge acknowledged that this should not go into the registry and that she was in no way inputting it in the registry, right?
It seems a little bit unclear to me. She says if you mark the XX, it cannot go in, and beyond that, she said, I cannot address your concerns. But as a result...
Well, because your concerns sound in terms of like what happens in a computer system, right? She addressed the issue of what you check off to ensure that it does not go into the registry. And that's what she did.
I don't know if that's what she did. She noted that that is what she was told, that if she doesn't mark the X, that it doesn't go in. It was unclear. She doesn't then make an order, I'm not marking the X. But
But she acknowledges that this is not an order that should go into the registry, right?
Not in so many words.
What do you mean not in so many words? She said exactly that. This is not an order that should be in the registry because of the nature of the case.
And yet it did enter into the registry as a direct
Well, then
result
that's a
of her
different
order.
thing, right? That's a different scenario than you saying that the judge is the one who caused this to happen.
The judge's order was entered into the registry in a way that entered into the system in a way that it entered into the registry. And that is the issue, because if we cannot address that through the court's order.
Counsel, I think, Counsel in Family Court raised the issue, of course, and said that herself that she had observed that previous Article 3 TOPs had made it into the registry when they're not supposed to. But what data do we have about the prevalence of that, if any?
The family court judge acknowledges that she has seen this happen before, and that it has happened before. The dashboard of the Order Protection Registry notes that there are thousands of non-required orders of protection, temporary orders of protection, being entered from family court into the registry.
So it seems like possibly this is a problem that's not the fault of the family court judge, but maybe something with the IT program. I mean, obviously, I think everybody agrees this should not have gone into the registry.
I certainly would hope that everyone agrees that this should not have gone into the registry, because Executive Law 221-A sub 1 enumerates every article of the Family Court Act and in criminal procedure where orders of protection should go into the registry, and Article 3 is left off that list, clearly intentionally. And so where this is happening as a result of the family court's order, I am here seeking the voice of this bench to clarify for the family court, this cannot happen. This is in direct contradiction.
Was it unclear to the family court judge that this order should not be entered into the registry? And if so, what in the record suggests that it was unclear to the family court judge?
The family court judge said she cannot grant the relief that trial counsel was asking for, which was to issue the directive on a short order or in some other way that would guarantee that the stigma of my 15-year-old client's information entering into the registry. And the court said it could not do that.
Wait, counsel, I think the court said I can't use a handwritten form. Not that I can't do that. I can't do it the way that you are asking me to do it. The court specifically said, for Article 3, temporary orders of protection requires a specific double X by the clerk that it should not be going into the registry, right? The court absolutely knew it shouldn't. And what it said was not that I won't do this. It said OCA has told us not to do handwritten forms, which is what you asked for. Was it you or your colleague asked for? It says we have to use the online form. So, and if I don't check that box, it won't go in the registry. And I know that Article 3 temporary orders don't go in the registry. I mean, that's straightforward from the record. I don't think I'm making that up.
And yet we end up in a situation where, as a result of the family,
some kind of IT issue.
I mean, it would be, to me, there's nothing in this record that suggests that this was an intentional decision by the court or OCA to upload the TOP into the registry. That's clear. This record does not show otherwise. It's a glitch. So the problem is do we have this whole appeal, and you're asking us as an appellate court to now do something. And I'm not sure we can do anything here in this context. What I think legal aid can do on behalf of clients that you believe have been unfairly subjected to this, what you describe, is to perhaps communicate with the Office of Court Administration and their IT department to look into what happened here or in the other cases you described. But I don't see the appellate issue that we have to resolve right now.
And it's not necessarily an OCA IT issue. It is however the registry interfaces with the computer systems that the clerks are using. That's the issue. It's not the issue about what the judge does. And you're asking the judge to use a paper format that the judge is not permitted to use.
I'm asking the family court to ensure that the statute is not violated as it was here. And if the court is saying that there's a double X box on the web form that was designed to auto-upload into the registry, that's what it was created for. If there's a double X form on an Article 3 order of protection that says, yes, enter, or no, don't enter, that's an inherent problem, because there should never be a yes, enter if we are all in agreement that an Article 3 order of protection cannot lawfully enter to the domestic
Counsel,
violence registry.
Just to, before you have to sit down,
Yes.
you mentioned that there was some evidence of a number of TOPs in the registry that should not be there, Article 3. Where is that in the record, if you have that at your fingertips?
So in the transcript, there is a discussion between counsel and the court that that there have been other cases.
So essentially it's anecdotal, right? It's something that a lawyer says happened to a previous client. There's not actual evidence of it from direct evidence.
And the family court says, yes, I know that there have been consequences.
Again,
and
anecdotal.
the history of that knowledge is not in the record. The domestic violence registry dashboard records that, which is cited in the brief. I can look for the page for the court.
Also
Oh,
understanding.
go ahead and do that, please. What was the page number? I'm sorry, Justice Michael, just a minute. I'll let you ask your question. I just want to get this one thing. It's in your brief, counsel?
Yes, so on
It's-
page 11,
And it's from the dashboard, it is evident that this has happened. Is that what you're saying?
so from the dashboard, you can look at how many non-required, and I will define that term as the dashboard defines it, family court temporary orders of protection were entered into the domestic violence registry. The dashboard itself defines non-required orders of protection as those that are not required by the court to be entered, such as Articles 4, 5, 6, 8, and 10 of the Family Court Act, but that the family court chooses to enter them into the registry regardless. The only other articles of the Family Court Act where orders of protection issue are Articles 3, that we're addressing, in Article 7, persons in need of supervision cases also involving children.
Thank you, counsel. Justice Michael may have a final question.
No, that's okay. Thank you.
Thank you.
May it please the court, Jameson Davies for the respondent. This appeal should be dismissed for several reasons. First, the appeal is moot as the appellant concedes. The order he purports to appeal from has been
Well, the argument is that this is a pervasive issue and ongoing because of the way in which the computer system interfaces with the registry.
Yes, so getting to that point, I don't think the exception to mootness is met here. There's nothing in the
But
record.
even forgetting that, I mean, we read your argument. What about this situation? Are you aware that the situation is going on? Did you address that in the record?
The presentment agency didn't take a position on the issue in the proceedings. I know that the counsel mentioned at least one other case. Counsel for the appellant mentioned one other case, but the presentment agency didn't take any position. I think we're aware of only what they've pointed to us, and the only specific actual cases are this one and one other that they point to where they filed a motion for.
Well, if this is an ongoing occurrence, then it isn't something that evades our review, right? So you do need to speak to that or have some information relevant to that.
Well, I think in order to satisfy the exception to the mootness doctrine, it's on the burden of the appellants to show that it's pervasive. It's such
What
that
we have in the record regarding what's listed on a dashboard referencing orders that are within it that are not required to be in it, is that not enough evidence of that?
Oh, I think one, that's not in the record, and two, it's a little bit unclear what all that means. It doesn't show what article, is it Article 3 or Article 7? And I think that gets to kind of a more fundamental point, which is just that the parties who actually have a stake in administering this system are not in this court on this appeal. The people who would know, there's no record of all of these things, how the system works, whether or not the TOPs get uploaded, because the entities that perform that function were never a part of this case. And I think that's the real issue, is that the appellants are essentially asking this court to issue a declaratory judgment about a specific statute where the parties who have the burden of administering that statute haven't had the chance to appear.
What is the issue with using with the proposal by the opposing side regarding the paper orders of protections?
So I think that goes to the same point. I'm not sure what the issues would be. I think the family court said that OCA had told her that she was not allowed to use those paper orders. We don't know why that's the case. It's probably something that OCA handles. But again, the OCA and the clerk's offices aren't here to explain and put in their position as to how they administer the law and how all of that works. So as far as I know, there's just no legal restriction on the short form order, but the way they administer their proceedings I can't speak to. And I think that really gets to the heart of why this appeal is improper.
Is there anything in the record that the family court was not aware that these orders should not be entered into the registry?
I think the family court agreed that the orders shouldn't be entered into the registry. And I think that also gets to the point where, what we're appealing an order, the temporary order of protection, and what the appellant is asking for is something entirely different that has nothing to do with the actual order that's on appeal. They're asking for a broad declaration that would bind presumably all the family courts and OCA and the clerk's office before anyone has had a chance to litigate the issue.
I mean, I think in the transcript, the family court judge specifically stated that Article 3 TOP should not be going into the registry. So I think that shows a pretty clear understanding that there was a problem. It wasn't her. She didn't think it was her fault. She agreed with the situation and just didn't know exactly how to handle it.
Right. I think that's right, Your Honor. And I think, it shows like this court's jurisdiction is generally limited to, affirming, reversing, or vacating an order. And what they're asking for has nothing to do with the actual order that was entered. The order was entered on consent. He agreed to the terms. They're asking for something that's entirely different. And maybe they can bring a declaratory judgment action. Maybe they can just informally work with the clerk's office. But this is not the venue to resolve that. Unless there are any other questions, we urge this court to dismiss the appeal.
Thank you, counsel.
In response, I would just note that the argument that we're making is being framed as a broad declaratory judgment and that the proper parties aren't here. And just to hone in on what is being asked and sought is that the court is acknowledging that there is a double X box and that you can click it and Article 3 or Orders of Protection entered the domestic violence registry, and somehow that happened here. The interpretation of Executive Law 221A is at issue here.
But is it because the court agreed with you that it shouldn't go in, and it was, and when it was resolved. So if you're asking us to narrow it, then it's almost certainly moot because the order was expunged and taken out. So if you're saying it's just about this order, well, then you've gotten all the relief you can possibly get.
It's about whether or not in any circumstance that an Article 3 order of protection can enter the registry.
And again, the court agreed with you that it can't. So I don't know what we could say. Yes, court, you are correct on that? I mean, sure, but that's not what you're asking.
Are you arguing about what the form looks like and the fact that there is even an option on the form for a double X checkbox?
Yes, where there is a form that has been designed to automatically upload into the registry.
Well, see, that's the thing. Are you aware of how those forms actually work?
I have read the manuals, and the form is designed, the form is interconnected with the registry, and I think that is very clear from the record.
But it's a format that references all orders of protections, and then you choose the type that you're using.
The GF6 form is specific to Article 3 temporary orders of protection, and the GF6A is for Article 3 final orders of protection. They are specific to the Article 3.
Thank you.
Thank you, counsel. Thank you both.
Thank you.
Maza v. 120 East 144th LLC. Please.
Good afternoon, Your Honors. Brian Isaac. I represent the plaintiff appellant in this matter. As you know from reading our brief, we believe that the trial court erred in denying our motion for summary judgment under 240.
Well, let's say we agree that the plaintiff met prima facie case. Would you agree with us, or with me, Mr. Isaac, that when there's a document generated closer in time to the accident than litigation prepared document, that document might have a little traction here? For example, on 322 of the record, the actual incident report that actually contains a potential admission against interest.
So let me answer it this way, Judge Schulman. The answer is yes, I would agree with the proposition generically.
And that, in turn, would create an issue of fact on the question of whether there was a 240 violation.
Except the problem is that the accident report itself is written by Mr. Costello, who has no personal knowledge of what's transpiring. If you look at the accident report as well, and that's our second point, which I know you know, it really doesn't matter whether or not the bucket fell or it didn't fall. We think that the Romero affidavit is purely a feigned factual issue, but if you look at the Fernandez case, this is something where everyone's agreeing that it was work done on the bucket. The plaintiff's position is that, obviously, is that the bucket fell, struck him, 1,000 pounds, he's hurt. Defense position, as I understand it from the accident report that you referenced, is that the plaintiff put his foot on the bucket, and they said, right, like a stool, and then went up and got his foot crushed. Either way, you're dealing with an elevation-related problem.
No, I don't think that's right. There's nothing that's falling on the plaintiff. He got wedged. That's not elevation. That's a completely different thing.
My point, Your Honor, is this. If you look, the Runner case, right? The Runner case.
Yes,
No,
I
know you
think
know
it's
it.
different. I
know
think
you
it's,
know it.
okay, if the bucket fell on the plaintiff, that's not what's happening here.
Or
There-
possibly.
Who knows? There are two completely different versions, right?
I understand. So let me deal with it that way. Just the point I would make relative to that, Judge Scarpula, is that, and this is how I look at Runner, I know people look at it differently, but Runner was an injury caused by ascension, not by descension. Yes, the 800-pound reel was going down, but the plaintiff's hand went up, got hurt. But let's leave that alone. If you look at the affidavit that Romero put in the first time, right? This is good lawyering on the part of plaintiffs.
Right.
He says, I don't know anything about this accident, right? I mean, that's his argument. I just don't know. I was there. I didn't see it.
He was the one that was driving the
He was
bobsled.
the one that was driving it. And we have an affidavit from an investigator who's a DH and a real good investigator saying, I spoke to him for 90 minutes, used the term debriefing, and said he doesn't know anything about this condition. This is what he says in his second affidavit. I did not see how Mr. Maza's accident occurred, 312 of the record, but I am certain that the incident did not involve a bobcat basket that fell.
Right.
But this is what he says in the first affidavit, and let's use, Judge Schulman, your first in time versus later in time analysis.
Not for nothing, but on page 313, the next sentence on that affirmation you were just reading was, after the incident, Mr. Maza said that the incident was his fault because he had put his foot in the machine.
Yes, no question about it. That actually, Judge Kapnick, furthers my point, because if that was the situation, right, that's what he would have said. He didn't say that
No,
in the
but
first
that's not
affidavit.
right. We can't decide that on a summary judgment motion. How can we decide that? That raises an issue of fact. And we've said many times with respect to plaintiff who has a slightly different version of events in statement 1 and statement 2, that would not prevent summary judgment. So the fact that on one affidavit he says more than the other, the person who's giving a completely different version of the accident, just because it's on behalf of defendant doesn't make it any less an issue of fact.
I'm not my time is up. Please, my answer? I'm not suggesting, and you know I'm on record in thousands of cases talking about summary judgment, you can't decide credibility issues. But I do think that, and I'll deal with this on my reply, when you look at what he said in Affidavit 1, when he says, I don't know anything about the cause, I don't think you can come back when you make an affirmative statement of fact, and then through clever linguistics say, you know what, I'm gonna get around that by phrasing the issue in the negative. Even though I didn't know what happened, I know what didn't happen. I think that implicates the feigned factual issue doctrine.
Thank you, counsel.
Thank you.
May it please the court, Darrell John, Conway Farrell, Curtin and Kelly for the respondent.
So
Counsel, do you want to
yeah.
start with that?
Yeah,
What Mr. Isaac says is a contradiction between the two affidavits and that they cannot be harmonized.
Let's look at the affidavit.
I am.
Page
short, I am not a witness
248,
to the accident.
248 of the record. He says, while operating the Bobcat, I suddenly and unexpectedly noticed John Maza was present and injured by the bucket hoist attachment. I did not witness how he got hurt. That's all he says.
He says, I
doesn't-
could not tell why he was there or what he was doing.
Yep.
Okay, but does it sound like on page 312, which Mr. Isaac just read, which was the second affirmation, where he said, again, he said, I didn't see how the accident occurred, but I am certain that the incident did not involve a bobcat bucket that fell.
Yes.
Is that contradictory? Is that just
It
more
is not.
detail? How do you explain that?
It is not. In the plaintiff's own version of the accident, and that starts on page 107 of the record, the 1,000-pound bucket is on the ground. In the affidavit, though, 248 of the record that was submitted, the plaintiff in his testimony, starting on page 107 of the record, going to 120, is in the process, along with Edwin C, in affixing it. But look at page 248, the affidavit submitted by the plaintiff, and he says the bucket had just been changed shortly. He's not talking about in the process of being changed. He's not talking about the plaintiff with Herculean strength lifting up a 1,000-pound bucket and putting it 2 feet up on an attachment so that it could fall back on him. I want to direct the court's attention to page 345 of the record. 345 is a photograph taken, 354 is a photograph taken of the plaintiff 3 minutes after the accident, and his left foot is exposed. The plaintiff's summary judgment motion, the arguments are replete that the foot was crushed. The big toe on the left foot had one fracture, and it is a complete foot there. It is not a 1,000-pound object, and this is the province of
Counsel,
the
I don't
jury.
think we're qualified. I mean, all due respect, I looked at that photo. It was painful to look at.
Yeah.
I don't think we can say, we're not doctors, about whether this could be caused by 1,000 pounds of pressure or by 200 pounds of pressure, whatever.
Right. I'm just saying, Your Honor, that it wasn't a comminuted crush factor as described without any reference in the plaintiff's appellate papers. That's all I'm saying here. As far as the incident report, right after the incident report, Mr. Costello gave a presentation to the workers on avoiding pinch injuries. This is all jury province. Why would he give a presentation on avoiding pinch? Right after the incident, he spoke to both Maza and Soteros, and he was told that it isn't that he put it on the bucket, he put his foot on the connection plate. The connection plate is then affixed to the bucket, and it got squeezed between there. This isn't a 1,000-pound object that the plaintiff was trying to attach while 2 feet in the air that fell on him. This is a squeeze
Soteros
injury.
is the co-worker, right?
Is the co-worker.
And the co-worker says in his affidavit that after the incident, Maza said that the incident was his fault, not just in the incident report, but he says it in an affidavit, right?
Yeah.
So they're both parties. That's a party statement, could be a party admission, right? Not just the incident report, but the actual affidavit.
Yes.
Okay.
Thank you, Counsel.
Thank you, Your Honor.
Any other questions?
So, Your Honor, if you take a look at the page after 354, which I probably should have mentioned before, that's the photograph that the defendant gave us. That's not my photograph, that's their photograph. It's the Bobcat with no bucket on it. I'm just saying. Let me talk about the feigned factuals, because it seems like that's where I need to go. I just want to read to you what was said, okay? This is what was said in Affidavit 2. I did not see how Mr. Maza's accident occurred, but I am certain that the incident did not involve a Bobcat basket that fell. This is what he said in Affidavit 1. 3 things. I'm just going to read them to you. 1, I cannot make any personal determinations regarding the cause. He used the word cause of the accident. 2, I am not a witness to how the accident happened or what caused it. His words, not mine. 3, I do not know the condition of the basket at the time or what part of the basket struck Mr. Munoz or why it happened. With all due respect, that is a semantic trick. You can't say, I don't know.
I mean, I hear what you're saying. I mean, we all looked at them. They're short little affidavits. But I guess the concern is, does in the second affirmation where he says, I don't know exactly how it happened, but I know that the 1,000 bucket did not fall on his foot. And I'm trying to see if I think that that's contravention, or is just saying, look, I'm not sure what happened, but this is sure like what did not happen.
So I'm gonna say something that wasn't in the briefs, but I'll say it anyway. I know what this court has said. Okay, if you look at Faulkner and you look at Bossert, you know the cases better than I do. This court has been pretty clear about that. If you can reconcile what someone said at one time with something that someone said another time, that's a question of fact. I don't think this is reconcilable because in this case, when you say you don't know the cause and you don't know why it happened, I don't think you can come back with another affidavit.
What about counsel? What about his statement? After the incident, plaintiff said the incident was my fault because he put his foot in the machine. That was nothing he said in the first affidavit. It clearly doesn't contradict everything he says in the affidavit. And if it's true, it's a statement against interest, which is admissible as an exception to the hearsay rule.
Your Honor, it may be, but again, that wasn't in the first affidavit.
Yeah, but that, again, not being in doesn't make it false or feigned, right?
I understand.
We've said that many times.
I understand, but again, the statements that I read, if they knew, if Romero knew what happened in the accident, he would have said so. To throw in a statement saying, hey, he apologized after is exactly the same thing.
How many times have we said, just because plaintiff didn't say it in his accident report and he testifies to it several months later, doesn't mean that it's a feigned issue of fact?
And that case is Rahm against Eurostrecht, it's mine. I have it, I know
so
it.
you
But,
know
but
what
what I'm saying is, when you say you don't know what happened, you don't know a cause, I don't think you could come back by using negative implication evidence and defeat that. That, to me, is what you can't do.
Thank
Thanks
you,
for listening
counsel.
to me.
Thank you both. We're going to hear Iuso v. State of New York and Al-Shami versus State of New York together. Please.
Good afternoon. May it please the court. I'm Robert J. Valley Jr. I'm here with my colleagues and some of the claimants in the Iuso and Al-Shami matters that are both before you. The issues in these cases are effectively identical, except for a issue involving the correction notice in Iuso and then the accompanying issue in Iuso as well. For the most part, the state has abandoned the rulings of the lower court as to why it granted the motion to dismiss, and rightfully so, because they're wrong. Instead, the state has now proffered new reasons, albeit jurisdictional, so I don't know if we have a preservation issue or not. And in essence, what the state is asking you to do is to take the standards of the Court of Claims Act, take the guidance that the Court of Appeals provided in Lepkowski, and raise the bar. Raise it to a point that it makes a claim against the state for an FLSA collective virtually insurmountable.
So what you are saying is, and this was a pre-answer motion to dismiss?
This is the state made a pre-answer motion to dismiss. Your Honor, I will
And what
admit
you're
to-
saying is that you alleged enough in your pleading, your initial pleading, to at least get you over that hump and continue on with the case.
Oh, did we ever, Judge? The Act and Lepkowski have very strict rules, and I understand now that the jurisdictional requirements in the Court of Claims are quite high.
Yes, they are.
Can't fix the error because you're out of the box in the first
But
place.
even saying that, when you agree, you put in enough into your complaints.
Judge, I know I have time, but we specify each and every FLSA claim. We specify what claims each claimant is raising. We specify who their employer is, their work address, their home address. We provide the pay rates, the overtime rates, and the correct overtime rates.
And you put some exhibits attached
Oh,
to
Your
that
Honor.
all try to lay out the different dates and the amounts to the extent you could, right?
Yes, Your Honor. We followed the act, and then we followed Lepkowski. The one issue the state raises is it wants dates, and then it wants individual weekly totals. That is not an FLSA requirement. It is not a requirement under the act, nor under Lepkowski. In fact, the word time is used, not the word date. And I understand, might it have been better? Sure. But for me, adding 26 different dates into the complaint may have been confusing, but telling the court the correct payday is the Thursday after the pay period, they paid him 28 days later on the 5th Thursday. That's wrong. That's really simple to me. So
when you ultimately, the claim is that the original service papers were deficient and you completed it from the March to May period. And then you put it all together, and there's really no dispute that when it was filed in May, it was within the 6-month period as required by the statute.
that's a great point, Your Honor. I think the lower court conflated the dates and then conflated the arose versus accrued issue. Because when you use the arose issue, we're within the proper time frame. But if you use the accrued issue, we're outside the box. But yes, I'll stay in front of the mic. I apologize. But yes, you're right. We are well within the time frame.
So the real issue is your claim to seek a late claim for the 22-23 period, where you're definitely, when you are filing it years later, it's not within the 6-month period of the 22-23 period. I mean, that's really required, and you missed that one, right?
Well, no. The late claim is always going to be beyond the 6-month period, Your Honor, because it's late.
No, but in the context of the Court of Claims, where there's been a waiver of sovereign immunity, which has constraints, does this do an end run around the 6-month statute of limitations?
No, Your Honor, it's actually called for in 10B of the Court of Claims Act, especially in a case like this, where you have the FLSA that allows for a 2-year or 3-year statute. To limit the claimants to the 6 months would allow the employer, in this case the state, to cheat them out of wages. And in fact, this state, we have a 6-year statute for wage claims.
But I mean, you have to put in some justification for not filing. And what was your justification for 2022 and 2023?
The claimants had just come to us, Your Honor. We were not aware of this before. Some of the claimants themselves did not even realize they were being cheated.
Did you put in affidavits to that effect?
I don't believe we need them at this stage of the proceeding.
You don't need any justification? You can go back 30 years, 6 years, 7 years, 2
No,
years? How
Your Honor,
long?
I'm limited by the FLSA and I'm limited by well, not the labor law, but the FLSA. I can only go back 2 or 3 years.
You think you can do that without showing any justification for not filing when the claims arose?
Well, we did, Your Honor.
Then what would be the point of the 6-month statute? It's exactly my colleague's question. Wouldn't that just be an automatic run around the 6-month statute?
No, Your Honor, it's not an end run around the statute. It's because this issue
So
is...
again, what justification did you put in? Did you put in affidavits? I didn't know that this was a claim. I didn't know that I had to do this. Anything like that?
We did not, Your Honor.
Okay.
And it's
Parenthetically, did you attach, isn't there an issue with failing to attach a pleading, which is also a statutory requirement?
That's the accompanying issue, Your Honor, and I apologize.
And the case law is clear on that.
Sorry, sir?
The case law is clear on that.
Actually, Your Honor, I found a case, and I will admit, old dog, new tricks. I put it into AI. I found a 1991 Court of Claims case that I will provide to counsel and submit as supplemental authority. It's the exact issue. It's a claim that was brought that's late, but because, in this case, the claim is filed early. It's not filed late, and then the state complains, you didn't file it at the same time. Well, you had it early. I've never had a defendant object to me that we've provided something early. So
Thank you, counsel.
The purpose, thank you, Your Honor.
Please.
May it please the court, Cleland Welton for the defendants. The claims in these cases do not meet the strict conditions that the legislature placed upon the state's limited waiver of its sovereign immunity. To invoke that limited waiver, the claim must allege on its face all.
Counsel, would you concede that you have to consider the FSLA in determining also the pleading requirements of the Court of Claims Act? Because that's where the substantive law comes from.
Oh, absolutely, Your Honor.
Okay.
We have to consider that, and the FL.
So if that's the case, using that as a predicate, then every time that you have a new pay period, you've got a new cause of action
Exactly
under
right.
the FSLA, right?
Exactly right, and that's why we win, because they have a new cause of action every time that occurs, a new claim.
Uh-huh.
Every new claim, you have to allege the time when the claim arises. They haven't done that for any of the claims. They've alleged a whole set of other different dates, but not the dates on which their claims.
But your client knows how many pay periods were within the period of time that they're talking about in the complaint, or no?
I'm sorry?
Isn't the number of pay periods within the period alleged in the complaint well known to your client?
Well, sure, they're on our records, Your Honor, but that means they lose under Lefkowski, because if we have to go look at our records to figure out the time when a claim arose.
But so much else is specified in this complaint. It's one is 123 pages long, the claim, and another's much longer than that. And they specify the various ways that the FSLA was allegedly violated.
That's the nature of the claim, Your Honor?
Yeah, and they specify some of the timing. You have an issue with the timing and with the quantification of damages, I guess, right?
That's right, Your Honor. They have to satisfy the strict and literal requirements of Court of Claims Act, Section 11B, to get into the Court of Claims. They haven't done that here for precisely the reason you were indicating.
But these claims are continuing to arise. So how would they satisfy going back on each of the continuing to arise claims to provide that information when you have the overall information?
They need, for each claim that they want to assert against the state, they need to allege the time when that claim arose, and they need to allege the damages that are associated with that claim. And they haven't done either of those two things here, and the claim fails for those reasons. Under Lepkowski and under Wright, they have to follow the strict and literal requirements of Court of Claims Act, Section 11B, and they just haven't done that here. They haven't tried to identify any date on which any claim arose. They had the opportunity in their reply brief to say, no, we allege this, and they didn't do that. There's no date.
Wait, but they put in, so I worked this 2-week period. During that period, I worked this much overtime that I didn't get paid for, right?
They have alleged that, yes, Your Honor.
They did that. They put in a chart that showed that, right? What more are you saying they needed to do?
The date on which their claims arose. And
During that 2-week pay period, that's when that claim arose. Here's how many hours they worked. Here's how much overtime they were entitled to. Here's their job title. What is it that you're saying is missing?
Respectfully, Your Honor, that's incorrect, because as Justice Moulton was indicating, a new claim arises when they fail to be paid, when the paycheck is issued and doesn't include the overtime that they're claiming. That's a different date. They've alleged dates where they worked, but they acknowledge in their reply briefs that they
So as long as it's within the 6-month period, what's the problem?
they haven't satisfied the requirement.
Okay. So you're saying that they have to put at 3:43 p.m. on Tuesday, I worked 15 minutes extra, and without that, that's not enough to allege a claim? I have not found a single case that says that, which is literally what you are saying here.
It follows directly from Section 11B.
No, it doesn't follow directly. That section says, here's my 2-week period. Here's the hours I worked. Here's the overtime I worked, which I didn't get paid for. Here's my regular rate, my overtime rate. They don't have to, I have not found a single case, if you have, that says that I have to identify on 15 minutes here, and that's when my claim arose. I haven't seen that.
No, you may be misunderstanding my argument.
I think maybe I am, because
What they need to allege is the date of the paycheck, because the paycheck, if the paycheck omits the overtime pay that they're demanding, that is when the claim under the FLSA arises. And so that's the date when the claim arose under Section 11B of the Court of Claims Act.
Are you saying that they get paid, everyone gets paid 2 weeks after they work, right? That's their allegation, that they get paid 2 weeks late after they worked. In fact, I'm pretty sure everyone in the state gets paid 2 weeks after they worked. You're saying that that's not sufficient?
No, Your Honor, because under Lepkowski, if we have to go look at our records to figure out the dates of the claims, the dates when the claims arose, then that is fatal to.
So your argument is that the exact date has to be listed, not the 2-week period.
Because the 2-week period is a different date. The 2-week period is a date when they worked, but the date when they worked is not by their concession in their reply briefs. They acknowledge that's not when the claims arose. The claims arose on the dates when they weren't paid.
Claims are arising as they're continuing to work.
Respectfully, Your Honor, no, the claim arises on the pay date. On all their federal cases that they cite in their briefs, the claim arises under the FLSA on the date when the payment is due. If we get to the pay date and they don't get their overtime payment, then a new claim arises every time that happens.
But you're aware of when the pay date is, correct?
It is in our records, in the state's records, but that is exactly why they lose under Lepkowski. If we have to go look in our records to find the material that should have been in the claim,
The chart that they submitted, does that not have the pay periods listed?
it does not. It has weeks during which they worked. It doesn't indicate when the pay periods ended.
Yeah, but
It doesn't.
But say you're dealing with 50 plaintiffs here, and there's a 6-month period, say from September to May, and they have a chart, so you know who they are, where they work, et cetera. You have all that information. All you have to do is get a data entry person to plug it in, and it'll come out. You're saying that because you have to have someone take a little computer time to just sort it out, that's fatally defective here?
That's what Lepkowski says, Your Honor. I'm sorry, if you read the case, if we have to go look in our records to find material that should have been in the claim, and it would have been just as easy for the claimants to put in the dates of their paychecks into their
But the
claim.
claimants in the case that you just cited, they didn't specify their work locations or the damages that they sought, and the claim was unverified. We don't have that here.
Right. Sure, those are separate issues under Section 11 of the Court of Claims Act. That's not the issue that we've raised here. They haven't alleged the time, and I would also point out they have not alleged the damages that are associated with any individual claim. And without that information, we can't go look and see were these individuals in fact underpaid on these pay dates, because we don't know how much money they say they should have received on any individual pay date, how much money they got on the individual pay date. And without that, we can't investigate the claims. And that too required us to go looking into our records to figure out, is this material, are these allegations true? If we have to go and do that, if we have to go and put that information together, then
Understood, counsel. Thank you.
it fails. Thank you.
So, counsel, I was wondering if you could address, since your adversary here indicated numerous times that if he has to go, or if his people have to go into the records and start looking that up, that you didn't do enough.
No.
So now what do you say about that? And is that what the Lepkowski case says?
Lepkowski kind of requires that, Your Honor. It does, but that's what we
So how
presented.
how do we get around that?
Oh, because you don't need any of their records. Our chart has the 6-month period. The matter of Geneva, which they cited, which is Fourth Department, says date or range of dates. So not only do we provide a range of
But
dates,
counsel, may I interrupt you a second? His argument is that you didn't put your pay date down.
that's actually wrong, Your Honor. So
That's
first of
what I-
all,
okay.
date is not required. We alleged that the pay date is the Thursday after the pay period.
And you put the pay period.
Yes, we put the pay
Okay,
period and
so
we
right.
put the...
So, so
just
what would
because
they
you
have to
didn't-
really look up?
Nothing, Your Honor. They don't. The bottom line is that these are meritorious claims, and they're not going to attack us on the merits. They have to attack us on jurisdiction. That's the bottom line. If you look at our chart has every person, when they worked, if they worked 0, if they worked less than 40, they worked more than 40. We added it up for them. They want us to literally enter each week, so it's 100 people, 5
Did you
different
list the
claims.
damages? How much?
Sorry?
Did you list the damages within that chart?
We did. No, not within the chart, in the next chart.
Okay. Are the damages continuing to accrue?
That's one of the issues, Your Honor, with the jurisdictional issue, is that the damages are continuing to happen to this very day. So to provide counsel with contemporaneous data is virtually, no, actually, it's not virtually impossible, it's impossible. So we struggle every 6 months to do this because the state cannot consent to stay the process because it's jurisdictional, at least they won't. So you're stuck with this jurisdictional circular argument. We have to keep doing it. Thank you.
Thank you, counsel. Thank you both. Prosite, specialty management via Altruist.
Good afternoon. Aaron Lauderstein on behalf of the appellants. Your Honors, this appeal presents a pure question of contractual interpretation, which is reviewed de novo. Under the plain language of the parties' agreement, the respondent, Altruist, agreed to perform 9 specified minimum services in exchange
Your contention is that the language of the contract is plain?
Yes, Your Honor. It could have been clearer, but that doesn't render it ambiguous. For the contract to be ambiguous, we would need something more here.
Well, which they did, which the court below did when he had the hearing and heard extrinsic evidence from 2 Prosite officers who made it clear that Altruist was complying with the contract.
So, Justice Shulman, the extrinsic evidence obviously does not come in if the contract is unambiguous. You start with the premise that a contract, especially one that is fully integrated like this one, that is unambiguous, does not permit the introduction of extrinsic evidence to vary or alter its terms.
That's kind of a standard thing. We all know that. But in this amendment to the niche management agreement, on Section 2A, it was something that was added to be a new Section 6.1. I think that's the couple sentences that the judge found was ambiguous, and we've all been reading, certainly I've been reading. So how is that not somewhat ambiguous to figure out what exactly was supposed to be going on here? I understand, I'm putting aside the extrinsic evidence, because that doesn't come in until we decide that's ambiguous.
Understood, Justice Kaepernick.
There's some all or none, kind of an odd
Again,
way of
I will
writing the
be the
contract.
first to admit, not drafted as clearly as it could have been.
And it relates to performance, right? So how are we to decipher when performance happens? Does it happen some of the time, all of the time, or none of the time?
Well, there are 2 sentences that are at issue here, and that's the first 2 sentences of this amended Section 6.1. The first sentence creates an affirmative obligation, and it says hereby, right, affirmatively, hereby Altruist is authorized and obligated to perform all of the minimum services set forth in this Section 6.1. And then it defines the minimum services below, and this is a capital minimum services, so that creates an affirmative obligation to start with respect to any and or all captive capabilities niche transactions. Anything that the company generates within the captive program, Altruist is obligated to perform all of those.
But you don't read that section in a vacuum. You read it in conjunction with the other parts of the clause. So how do you square that language of some, all, or none?
Exactly. So the second sentence does not speak to obligation, but speaks to control. So in the first sentence, Altruist is authorized and obligated to perform. In the second sentence, Prosite retains the sole discretion, the sole option to tell Altruist whether or not it can perform a particular service for a particular captive. For example,
that it can, that it shall. That is a completely different thing to say can. The first sentence you're saying obligates the company to do everything. But the second sentence is the exact opposite. It says you don't have to do anything at all unless you are told by the company to do some, all, or none. And so that in and of itself is completely opposite from, no, you must do them all.
If that is the correct reading, if that's the correct interpretation.
That seems like the most natural, to keep them both as not one negating the other, which is also an obligation we have to do, right?
100%. And one negating the other is actually what Altruist's reading would do. And let me explain why. If you interpret the second sentence to say that Altruist is obligated to perform only those services that are requested by Prosite, then the first sentence that says it is hereby obligated to perform all of the minimum services is not only meaningless, but wrong. It is not hereby obligated.
It just makes it ambiguous. That's the whole point. It's not irreconcilable to say you're required to do all of these services, but we you don't have to do them until we tell you which ones they are. You can't, of these 9, you can't say, no, I won't do it if we tell you to do it. That's a reasonable interpretation of it too.
That's not what the agreement actually says, Your Honor. It
Oh, I
says-
think that's exactly, well, that's, I mean, so the fact that you and I think it says 2 different things automatically means that it's ambiguous, right?
I mean, I know you and your adversary both think it initially thought that it was clear, but you thought it meant different things. So we're supposed to figure out if it's clear and who we agree with. I mean, I think it's hard to find this clear and unambiguous.
In the presence of 2 apparently conflicting provisions,
Yes.
if one explanation, one interpretation harmonizes them and the other does not, the one that would harmonize the 2 provisions would be the reasonable interpretation.
No, it's if they're both reasonable interpretations, then that means that it's ambiguous.
But an interpretation, Your Honor, would not be reasonable if it does, in fact, render these 2 in conflict with each other. So if there is an interpretation, if sentence 1 says A and sentence 2 says...
So tell me quickly, what do you think these 2 sentences say that can reconcile them so that we can think that you've got the right deal and we don't have to worry about the extrinsic evidence?
Today, the first day of this contract, Altruist is hereby obligated to perform these services, all 9 services. In the event that Prosite determines that Altruist should not perform a service for a particular captive, because remember, Altruist is being authorized to perform these services as an agent in fact on behalf of Prosite, Prosite retains ultimate control to tell Altruist, I do not want you to liaise with, to be the primary point of contact with captive 1, 2, and 4, because I want to control those relationships, not you. And so section 2, or sentence 2, speaks to that control issue. But the affirmative obligation is imposed on day 1, moment 1, on Altruist to perform all 9 minimum services across the board.
Thank you, counsel. You have time to rebuttal.
Thank you.
Good afternoon, Your Honors. May it please the court, Anthony Tessitore for the respondent.
So I guess I kind of think that's a good place for you to come in. So tell me how you understand the meaning of this, whether you think it's ambiguous or you can explain it nice and clear.
Sure, Your Honor. It's certainly Altruist's position that there is only one reasonable reading of the contract on the plain language, but the court ultimately concluded that the contract was susceptible to more than one reason. But briefly, on the language itself, I tell you that the court below told Prosite very clearly, I don't think that the plain language of the agreement supports your interpretation of the agreement. I agree with the way that Judge Viscoso has identified, harmonized into the different provisions of the agreement. And that's exactly
Counsel,
what the
may
court is
I
alluding
ask
to.
you, was Prosite involved in drafting the contract in the beginning?
It was integrally involved. In fact, Robert Bailey, who Judge Borak referred to, was the principal drafter and critically involved in the negotiations of the agreement.
And his view of it was
Is exactly as
and how
espoused
about
by
Altruist?
Altruist.
Was Altruist involved in drafting the contract?
Yes, they were.
And so did Altruist put up a witness who testified as to a different view
No,
than the Prosite view of what the contract meant?
The testimony from Prosite's witnesses and Altruist's witnesses matched.
Everyone believed that the contract said not what Altruist is arguing on this motion, right?
Not what Prosite is arguing.
I'm sorry, not what not what Prosite is arguing.
Correct.
No one who drafted this contract thinks that Prosite's view of the contract is correct.
You're 100% correct, Your Honor.
It's kind of like, I guess, disconcerting for Prosite when Mr. Bailey, is that what I'm saying? Mr. Bailey got up there and seemed to go along with you.
They are trying to distance themselves from their own executive who was responsible for negotiating, and agreeing, and executing the
Because
contract.
if you look at the extrinsic evidence, then it supports your view of what the contract says, right?
Correct, Your Honor. The court ultimately concluded that the contract was susceptible to more than one interpretation, which we disagree with. But in the end, the weight of the extrinsic evidence, the court concluded, which was entitled to refer to, absolutely and clearly inured to Altruist's benefit and our reasonable interpretation.
So you decided not to cross appeal, obviously. You're just opposing his
Correct, Your Honor.
Well, on this record, didn't Prosite actually pay your commissions when arguably you were doing nothing?
They paid.
Now they want it back?
And building up your capability, didn't they pay you like over $1 million commission initially?
Well, first of all, I think
2020?
the record supports in year one of the contract, Your Honor.
So if they felt you had to do all 9 minimum services from day one, as your friend says, they wouldn't have paid you that commission, correct?
Correct, Your Honor. They paid us under the first year of the contract, and it was clear that this was a forward-thinking agreement. There was a build-out that was going on, and they paid us anyway in year
Counsel,
one.
the first time that your client knew that Prosite was unhappy with the execution of the contract was in October of 2021, right? You got a letter, some correspondence, and then you got the notice in November of 2021.
Correct, Your Honor. There was some initial negotiations and discussions about the idea that we were not going to get paid. Our client was not going to get paid in October, and then it wasn't until November of that same year that we received a notice that of intention of breaching the breach of the contract. I will rest on my papers, Your Honor.
Thank you, Counsel. Please.
Thank you. Just to address a few points. Obviously, while if the contract is unambiguous, extrinsic evidence does not come in. I just wanted to mention briefly.
Well, how do you explain that none of your witnesses think that the company's view of the contract is correct?
Because when we're talking about Mr. Bailey as a company witness, he's testifying 2 years later. He had an acrimonious falling out with his former employer. I'd like to read from page 759 of the record, which was Mr. Bailey's email when negotiating this agreement in the first place, when the parties were negotiating and drafting. And he revised the original draft of this agreement to remove services that were not always going to be required. He said, I reviewed the copy provided and made some changes to make it clear that this is the agreement of the minimum of services we will expect and that each captive will have its own addendum with more specific duties, if there are any, that go beyond these minimums listed here. And then he says he removed all of the services that were not going to be required. 2 years later, after, again, a falling out between Mr. Bailey and the company and when he was no longer employed, he testified that these were, in fact, the services that were originally required. And then after further questioning, he said, well, actually, maybe they weren't really required up front. In addition, the thing that Mr. Bailey...
I'm sorry, I didn't mean to... Mr. Kavanaugh also had an acrimonious relationship?
Mr. Kavanaugh is also no longer with the company.
How about Mr. Hannon?
Mr. Hannon was with the company.
Mr. Hannon, all your witnesses say the same thing.
Mr. Hannon was with the company and then retired on good terms and left on good terms, but he did not say, Your Honor, that these were not the minimum services. And the additional point to note is that at a minimum, and this is according to Altruist's interpretation, it needed to be able to perform these services. So to be clear, these were Altruist's position here is that it was a services provider, and the value that it was receiving, the millions of dollars a year, was that it could provide these services. If it's incapable of performing them, not just on day one, but on day 365 or further, it has not performed its obligations as a services provider.
But that was an issue of fact. The judge didn't resolve right away on this.
The judge didn't.
You still, just excuse me.
Apologies.
My understanding is while finding that the extrinsic evidence supports a particular interpretation, you're still left with the issue of whether Altruist ratchet up its capabilities to be able to fully perform on day 365. Am I correct? That's the remaining issue of fact.
The remaining issue of fact is when Altruist was required to develop those services. But if the requirement was to develop them at the beginning, meaning if the panel were to agree that this is an obligation built into the contract, then there is undisputed evidence and there is no contest that Altruist never developed the capabilities. Whether it was required to perform them on day one or day 175 is irrelevant if it never performed.
Thank you, counsel.
Thank you.
U.S. Bank National v. Chait.
Good afternoon, Your Honors. Daniel H. Richland for the appellant, Mindy Chait. For our purposes, there was a 2012 action, 2015 action that was dismissed in 2022, and then 10 days later, the underlying action was commenced. The problem here is that this is a 205A case, where essentially if 205A doesn't apply, then you have to dismiss because it's untimely. The issue here is that my client wasn't served at the TNEC address. It's in the complaint, the 30-day notice, the 90-day notice, or pretty much anywhere. She was served at the apartment on a purported person under 308 subsection.
Is there ever wrong to serve the person at the premises? Isn't that exactly what the statute allows you to do?
It does. She just
So
didn't
what's
live
the
there.
problem then?
She didn't live there.
So what? If you can always serve at the premises. There's no doubt about it.
Actually, under 308 subsection 2, substitute service is only proper at the premises if she actually lived there, if it was her usual place of abode, or if it was her place of business. And the problem is it wasn't any of those three.
Was she living there at the time?
She was not. She lived in
So, okay, so is there not an argument that it is her place of business? She's renting it out?
That would not be a place of business, as that would be
okay, all
understood
right.
under the statute. I
Okay.
think a place of business is where you regularly work and appear and attend. The apartment you're renting out is someone else's residence. There's a lease in the record here. So even if that were the
You
case.
say the court did not have the discretion to do what it did in terms of saying that the second service was good, the 2024 service, I think it was.
It's interesting, actually, because our argument is that whether or not the 306B service or order is effective, it could not extend out the 6-month window under 205-A.
Right.
That's really the crux of this. That's from Pine and Myra, which both say that the discretionary extension of time under 306B.
Right.
Really, I think the answer to the questions that are being addressed on the where she lived, that would need a Travers hearing. So one easy way to resolve this is to reverse, remand for a Travers hearing, and then the outcome of that would basically dictate. However, I want to note that if my client did actually live at the premises, it would be a 1304 problem because it was only commenced 10 days after, and the service is 3 days after commencement. So effectively, if she was living there, then the 90-day notice is defective, and that would be a separate grounds for dismissal, which is an equally interesting problem because we say she lives in Teaneck.
Not a problem that's in front of us right this minute.
Exactly right, Your Honors. Thank you very much.
Thank you, counsel. Perez v. Tanya Towers. Please.
May it please the court, my name is Taylor Ash. I represent defendants appellants Tanya Towers and Skyline Restoration. The crux of the issue before this court is whether the 241 summary judgment that was granted in favor of plaintiff was proper, despite the fact that, one, the only competent evidence in the summary judgment record regarding the factual allegations come from plaintiff's self-serving
Did you submit any evidence rebutting the plaintiff's account of how this accident occurred when he was told to walk up or get himself up on scaffold piping to reach the level of where he needed to work rather than being provided with a ladder to do so?
There was precluded evidence. There were 3 witnesses.
Not precluded evidence. We're talking about actual evidence in the record. Did you provide evidence in the record of an alternate account of how this accident occurred?
There's not anybody in the record who was present at the time that the accident occurred. However, Mr. Tronosco, who was a witness for my client, Skyline Restoration, worked with Spring Scaffolding, the alleged employer here, and he said that they would not have, his quote was from his deposition, it was his expectation that Spring Scaffolding would provide ladders or an equivalent safe means of access to the scaffolding at issue.
But we have unrebutted testimony from the plaintiff that he was ordered, I think this was his 3rd day in construction without having no prior experience, climb up there and bring down the wooden boards. And he was a good soldier, and he followed by climbing up a scaffolding, which you and I know is not a safety device. So, and our case law, it's well settled that you can have an unwitnessed accident and achieve partial summary judgment on liability under 241. So as my colleague pointed out to you, unless there's something else to counter what Mr. Perez said, sounds like the court below was accurate.
Well, Your Honor, I would push back a little bit respectfully on the case law. Specifically, I would turn this court to page 10 of our briefing, which talks about the Wahab case in Mahana, and the Wahab case comes from Mahana. And what Mahana stands for the proposition of is that when the manner of the happening of the accident
is within the exclusive knowledge of the plaintiff, an award of summary judgment on 241 is inappropriate, and the defendant should have an opportunity to cross-examine the plaintiff and put the plaintiff's credibility at issue here. And the key reasoning in that case is credibility, Your Honors.
I mean, the thing is, you don't, if you would put in something on this summary judgment, I mean, a summary judgment is lay barrier proof, right? So you had to lay barrier proof. I mean, I know you talked about unaccepted, inadmissible evidence, which is inadmissible, but you say that Spring Scaffolding should have supplied the ladders, except there's testimony that they did not supply any ladders, that they were not available, and that the plaintiff saw other people going up on the scaffold the same way he was told to get up, so he figured that's how he was supposed to do it. So what did you, I mean, I think you had to put in something in opposition to this motion to at least raise the issue. You can't just say credibility. I mean, you can't, it has to be something.
Well, yes, Your Honor, I agree. There's a quote that I mentioned before, but also our witness testified that Spring would not have had their guys climbing the cross braces to go up the scaffold.
That's nice, but he testifies that that's exactly what it was.
I agree, Your Honor, but that creates an issue of fact.
Just having some speculative statement in the record that this would or could not have may not have happened does not create an issue of fact.
I see that I'm out of time. Can I respond?
You can answer the question.
This is not a speculative testimony. Mr. Tronosco testified that when he worked for Skyline, 80% of his subcontracting was to Skyline. He knew that company well, although he wasn't there on the day of the accident. He knows scaffolding work better than Mr. Perez, who said it was his first day working on construction. So that is where we have an issue of fact here. It's not some general allegation, but someone who knew the company that Mr. Perez was working for. Thank you.
Thank you, counsel.
Good afternoon, Your Honors. May it please the court, Carl Tegmeyer, Sanaki, Newman, and Turret for the plaintiff respondent. I think the court really hit the nail on the head, is that there was no evidence in opposition to our prima facie showing a summary judgment here under 240. The plaintiff testified, and it's undisputed. He asked for a ladder. He was told to look for one. He couldn't find it, and he was directed to climb up the scaffold regardless. So that's a violation of the statute right there, no ladder. There's no evidence in the record whatsoever that a ladder was generally available, let alone readily available, as is required.
What about counsel's indication that that her witness testified, well, I've worked with Spring for a long time, Spring Scaffolding, and they would always have ladders available for the workers, as opposed to your client who's, 3 days ever doing this type of work and had never worked on a scaffold before, I think you said.
Right, well, Your Honor, that's a witness with no direct personal knowledge. He was completely unaware that this accident even occurred, as there was no incident report generated from the accident. So he didn't, not only did he not know about it, not only was he not there on the day in question, he didn't even investigate it. He has no direct personal knowledge, and frankly, his testimony is just pure speculation. Speculation alone is not sufficient to defeat the plaintiff's prima facie showing. Just to address another argument the counsel didn't address that they put forth in their brief as to this was a gross misuse of a safety device. Judge, as you noted, scaffold climbing the cross bracing, that's not an adequate safety device here. And it can't be a gross misuse when he's directed to use the scaffold in that manner. Moreover, there was no tie-in given. They had rules that if you're over 6 feet, the general contractor's rules stated that you're supposed to be given a personal fall arrest safety device. He was not given that. He was 25 feet up when he fell. Moreover, the cross bracing on the scaffold broke, so the scaffold itself broke and failed. So there's multiple violations of the statute. There's violations of the owner and general contractor's absolute duty under 240, and there's no evidence to refute the prima facie showing. So unless there's any questions, I just rest on my brief. Thank you, Your Honor.
Thank you, counsel.
Just one point on rebuttal, Your Honors. The case law is clear that when the sole evidence is plaintiff's own self-serving testimony and there are credibility issues, which are the two quotes that I gave the court earlier, and the internal deposition of Mr. Perez. Mr. Perez has a very vague recollection of what happened, which is reflected on record 131 through 136. He could not recall the names of my clients, Tanya Towers.
That has nothing to do with the actual accident and the how the accident occurred.
Yes, Your Honor, I would agree. The only facts that plaintiff could remember, he couldn't remember which foot he hurt and which foot got put into a boot, but what he could remember were the facts necessary to predicate a 241 claim. That the fact that his alleged form...
Your opposition has put in nothing to rebut those claims. Not one piece of evidence that is not speculative.
Respectfully, Your Honor, I would disagree on the testimony of our witness is not speculative given his experience in construction. Those are all the points I have. For those reasons, we ask this court to reverse the lower court. Thank you.
Thank you, counsel. Thank you both. Sanchez Rodriguez v. Bruce.
Good afternoon, Your Honors. May it please the court. John Martin for Bergman and Bergman, Fields and Lamonsoff for the appellant plaintiff. The lower court in this matter erred in granting defendant's summary judgment motion as there exists multiple questions of fact as to defendant respondent's negligence, not only in the first party action, but also in the third party action which defendant brought. This matter involves a motor vehicle accident which happened in May of 2018 on Edward Grant Highway at its intersection with West 160.
Yes, we know the facts. And, you know, your client is making the left turn, and was that a violation of vehicle and traffic law 1141? That's the issue here. How do you suggest that the defendant could have avoided this accident?
Your Honor, defendant respondent could have avoided this accident by using his senses to observe that his lanes of traffic and driving were blocked by a cement truck that was blocking both travel lanes of southbound on
I know you say that in your brief, but in the photos, it looks like he's already in the intersection. The defendant's already in the intersection, therefore, it's on your client.
So, Your Honor, they're both in the intersection. And as this, the way this accident occurred, based on not just my client's testimony, but also on the defendant's testimony, is that my client was already through the intersection and he was already parallel with and on 169th and feet away from its crosswalk. Whereas defendant stated in his own terms, he traveled at 22 miles an hour southbound after darting around a cement truck that blocked his view of the intersection and required him to also violate the VTL by entering into a bicycle lane and a parking lane to travel southbound further on Edward Grant Highway.
Please continue.
With that, Your Honor, there exists a question of fact as to the defendant's negligence, not just in the first party action, but also in the third party action, which they brought on the belief that they had a credible case for subrogation to the third party defendant in that they were partially at fault along with the cement truck being in the intersection, blocking the two southbound lanes of traffic on Edward Grant Highway. And with that, Your Honor, I reserve my time. Thank you.
Thank you, counsel. Please.
Good afternoon. May it please the court. Patrick Neglia for the defendant respondent.
There's nothing, no evidence in the record whatsoever that my client darted around a cement truck. The evidence, and it's uncontradicted, is that the cement truck, which was partially or at one point fully blocking the intersection, began to back away out of the intersection. And when my client was free to proceed,
That's what allowed your client to move forward with the light in
Correct.
his favor.
and he's now going through an intersection with a green traffic light straight through the intersection, and my client made it about 75 to 80% through that intersection. We see where the cars are positioned, within the confines of the box of the intersection. One of the things the plaintiff is throwing against the wall here is that my client was somehow in a bicycle lane. Well, again, I'm going to submit to the court two things. One, my client is within the 4 boxes of the intersection. And two, from the photographs, it's not clear whether my client may have even slightly drifted in the bicycle lane. However, I'll concede, for the purposes of the next hypothetical I'm going to give you, let's just say my client drifted to the right and was now in the middle of the intersection in what we'll characterize as partially in a bicycle lane. Had my client struck a bicyclist, that would be approximate cause of the accident. But that's not what happened here. We have a car that's trying to make a left turn across oncoming traffic of Grant Avenue.
Counsel, was it your position that the plaintiff's vehicle was in the intersection before your client, or your client was there, and I mean, how did that exactly happen?
It's not my position, and I don't know if the
Or your
record
client's-
is necessarily clear on that. What I would propose, though, is because my client is, based on the positions of the vehicles, 3/4 of the way through the intersection, and from a stop, indicated that he was now at approximately 20 or 22 miles an hour. He was nearly through that intersection with a green traffic light, proceeding straight. And he would have been successful had a left-turning vehicle not attempted, coming in the oncoming direction, to cross over the oncoming lane of Grant Avenue.
Where did the other car hit his car?
The cars
left?
were
The left. I'm looking
kind of
at some
like-
pictures.
at an angle. If this is my client, a corner angle.
This is it, right?
Yeah. My client is, they're both Jeeps. Makes it a little interesting, but my client's Jeep is.
Somebody's red,
You had the
wasn't
gray,
it? One
that
was
was the
red.
defendant.
Yeah. Now, what I submit to the court is this idea that perhaps my client was in a bicycle lane is not a proximate cause of this accident. What it establishes is if there was a bicyclist in that position, instead of my client's vehicle, the left-turning plaintiff would have struck a bicyclist. One of the things I noticed in looking at the photographs is for the plaintiff to make that left turn, he needs to come a distance because he's turning on that side road, but it's a two-way roadway, and he needs to be on the right side of the double yellow line. If we look at the photographs, we can see that the plaintiff's vehicle is actually on the left side of the double yellow line, which to me is evidence that the plaintiff was trying to quickly make this left turn and beat my client's vehicle. Again, I go to the VTL, section 1141. My client is proceeding straight with a green light. Whatever obstruction was present is no longer there because the truck has now backed out, and my client has the right-of-way over a left-turning vehicle that's trying to cross over the oncoming lanes of Grant Avenue. And the last point I'm going to make is regarding my third-party action. That's only if this ever gets to a jury. Clearly, the fact that the truck was in the intersection may play a role in this accident. However, if I'm successful on appeal and the lower court is correct, which I state the lower court is absolutely correct, then my third-party action is moot, it's academic, and it's over.
We understand.
Thank you for your time.
Thank you, Counsel.
Your Honors, may it please the court quickly to rebut the issue of the photographs. Counsel's characterization of perhaps a little in the bike lane is not accurate based on those photos. You see his client's vehicle.
But I mean, does that have anything to do with the accident anyway?
In the way that the accident occurred, yes. So my client was stopped at a red light, and from the red light, after the light turned green, turned
We
left.
start
because
with that, right? 1 second. And so your client definitely doesn't have the right of way. Your client is taking a left turn, and the other car has the right of way, right?
If there was cars coming at the time my client was at the intersection.
No, I mean, the VTL just says,
Certainly,
right?
Your Honor.
So we start with that.
The VTL, yes, but when the intersection is for southbound traffic, the 2 lanes are completely blocked by not a moving, reversing concrete truck, as council likes to characterize it, but going by the concrete truck driver's own testimony, parked in blocking those 2 lanes on an angle truck. There was no ability for any traffic to continue southbound on Edward Grant Highway because it was blocked. My client saw that and made a left while there was no oncoming traffic in the 2 driving lanes. And then defendant testified in his deposition, of which there was 2, that the first deposition was, well, he didn't look to the left. I wasn't looking to the left. I was looking to the right, and I didn't see any traffic coming. And then in the second deposition was, well, I was going through, it was a green light when I approached the intersection, and I continued through at 22 miles an hour. You know, for my client who testified, they were stopped at a red light and moved forward at 5 miles an hour with caution to proceed through an intersection which is clearly having construction activities going on in it. You know, it's not reasonable for a driver who's coming southbound at that intersection to not stop and wait for the truck to clear its path forward before going into the bike lane, which is clear by the photos, is what happened in this case. Thank you, Your Honors.
Thank you, counsel. Thank you both. Taylor, v. City of New York.
To put it down.
Please.
If it please the court, it's well-established law in New York.
Counsel, give your appearance first.
Oh, I'm so sorry. Fred Lichtmacher, the law officer, Fred Lichtmacher, PC, excuse me. It's well-established in New York that even a single comment that's hostile to somebody based on a suspect classification can create a hostile work environment. And there's 2 cases about that you can look at, Captan and Golston. In this case, we have a client who was inundated. Detective Taylor was inundated with racist statements for a period of several years.
One thing your opponents make a point about saying is that neither your client nor Officer Reed made any complaints against Sergeant Totzek, you know, internally, administratively. Is that correct?
They did not. You're absolutely correct about that.
So what inference should we draw from that then?
The inference you could draw about that, and maybe I should have written about it, but what you could draw about it is it's not a good thing when you're an NYPD officer to make complaints. And I handle these, I've had several cases in such circumstances, and there's always retaliation, you know. But I did not bring it up in my papers. I'm offering it now. You can consider it or not, you know. But in any event, when things got unbearable and when he ultimately got hurt, he did resign. At that point in time, he retired, and he did apply for 3/4, and he did get it. Now,
So the injury is not a tort claim, as your friend made reference to, because you didn't file an appropriate notice of claim on that track. You're arguing really a violation of equal protection.
Yeah, you're correct. I mean, look, I understand that the Restoration Act has broadened, you know, our concept of what 8107 does. I'm going to look at it only through the eyes of 8107. And if you're showing racial hostility to somebody, and then you subject that person to a very dangerous situation, more dangerous than it would be for somebody else. He's on Percocet, which I neglected to mention. I did mention in my papers. I take that back. He's on, that's at 127, I believe, in the record. He's on Percocet. He has no gun. He's clearly disabled. And he says, well, he sent him out because he's a big guy. Okay?
Well, counsel, let's talk about that statement with regard to what the sergeant said there. There was no race indicated in that statement. Why should we ascribe any racial animus to that statement?
Thank you for that. Because the totality of the circumstances, the way this person has spoken about black people over the course of years on an ongoing basis, the comments that he's made about black activists are just ongoing. So from that, it's easy to infer, and that's what Taylor infers, this guy just didn't like black people. And that's the same thing that Haber-Hashem says, and the same thing that Reed says. And those are the only two people of color who were working there that we know of at that time. You know, and the important thing is, it's ongoing. It doesn't stop. I mean, it's not something that's done once or twice, and once or twice could be enough. But if you look at his rants from January 26 of 2019 till the date that my client got hurt, that's at 107. And if you look at statements that the plaintiff has made at 371 about from 2017 to 2019, these comments happen weekly. And it's very hard to interpret them any other way. And one thing I found almost comical, and there's nothing comical about Colin Kaepernick, what he did and the contribution he made to our country, you know, but he doesn't comment on Jerry Jones and the Dallas Cowboys taking a knee. He doesn't comment on Bernie Sanders taking a knee. The only one he's interested is Colin Kaepernick. Why? It's enough when this happens year after year, comment after comment, to associate it with, hey, this guy is not exactly friendly to people of color, and particularly to my plaintiff. Now, did he make any direct comments? Did he call him any nasty names? No, just treated him badly. And he knew he was being treated badly, and he was constantly getting these. Now, in terms of, you know, the other
Also,
side.
you can hold that thought. You have rebuttal time.
What's
Thanks.
I'm
Your
out of
time's up.
time?
You got the red light. So you have time in rebuttal, though. So, you know, you can pick up the thread there. Thank you.
Thank you.
Bo Malin Mayor for the City of New York. I want to pick up with some of the points that Your Honors made. So as to how he never filed a complaint, I think that's in part because he never was disciplined, demoted, denied a promotion, denied overtime, referred for investigation. He was never told to work different tasks or different hours than any other officers during the 3 years that these comments about the NFL protests.
But counsel, this is a 3211 motion. It's a pleading motion. The city human rights law gets a liberal reading. It's broad and remedial. You know, that fact that he didn't complain at the time is explicable. And he alleges all these other facts, so why aren't they sufficient to get him across the finish line on a motion to dismiss?
So I would quickly note that the parties have consistently treated this as a summary judgment motion, and both sides have submitted evidence.
Oh, that's true.
In
Okay.
response.
Yeah, you're right. You're right about that. And I guess we should treat both of them as summary judgment motion because facts were introduced. You're right about that.
And so as
But having those elements that you said does not take away from him being treated less well because of his race, right? Because that's what we're looking at. That's the standard, right?
understood, if he had shown that. So first,
Didn't he testify at some point that he couldn't wait to get out of the office at 5 o'clock, so he turned down overtime he might otherwise have taken, which I know is a big thing for the officers if they can get overtime. He didn't do it because he just wanted to get away from this sergeant. Did testify about that, right?
so I think that, okay, so first I want to address specifically the points made regarding the arrest, if I may. I know he did testify as to the overtime and his general feelings of not being happy with Sergeant Tochek, and I can address that as well. But if it's all right, I'd like to quickly address the arrest.
Sure.
Because that's his main claim. And so there's absolutely nothing connecting this particular arrest to racial discrimination as opposed to as...
Well, sending him out when he's not physically in a good condition to do so, and referencing his size, according to you, has nothing to do with race?
So although that can be a stereotype, as counsel pointed out, here we have the fact that plaintiff was in fact 6'7" and 200 and...
Well, in your brief, you seem to juxtapose that to a smaller officer, but we don't have any information in the record about how small the other officer was.
Correct, because all the information about comparators that...
Except what we do know is that the other officer's white, right? And we
So
do know that this person says, look at you and look at him. The only thing we know is that the officer he sends out is black and the other officer is white.
And sends out to a dangerous situation, right? Especially given the officer's physical limitations.
Potentially, Your Honor. I think the point I would make about this is that all of the reasons he gives for this, that there are other white officers, that there are past comments, could apply to any policing decision. that Toczek made with regard to plaintiff. It's always going to be the case that there are other white officers in the department. It's always going to be the case that he made these past comments, but we had 3 years of no adverse action. I don't believe there's any reason to infer that suddenly on this, sorry. I'm sorry.
You could, even without a specific adverse action, you could still have a hostile work environment. And with the exchange of communications and with the posters, that whole dynamic that was going on here, including the fact that other members of the auto crime unit were not happy being the recipient of these emails or these communications, that they actually told them to stay focused on their job and not on this other stuff, because it meant that other people in the unit, white people, found it distasteful.
Yes, Your Honor, and I wish
minimally.
I'm sorry. I wish I had more time to address that. I'm sure the council will discuss it, but the only point that I would make is to note the First Amendment issues raised in my brief regarding the opposition to protests as a general matter.
Thank you.
Okay. Good afternoon, Your Honors. Lalit Lumba from the Quinn Law Firm for Sergeant Toczek. I would just make the following points. This was a summary judgment motion by Sergeant Toczek, and there are allegations of racist comments in the complaint. There's allegations of other racist comments and remarks in the complaint. But when he was deposed and put under oath, the plaintiff stated that he never heard Sergeant Toczek make a racial slur. That's record page 253. That he never heard Sergeant Toczek direct any racial slur at anyone, including himself. That's record page 219 to 220.
I mean, is that required? Do I have to actually use the N-word or some other racial slur to create and to assert a claim?
Perhaps not, but here
I think not is for sure not.
But Your Honor,
What was required is that the person is treated less well because of their race.
And he's also stated that he wasn't treated any worse than any other officer in the unit.
Where?
That's in the record, Your Honor. It's in the brief and I would refer you to my brief on that. The plaintiff testified, and again, he testified differently than he alleged in the complaint, and that's why the lower court properly granted Sergeant Toczek's motion for summary judgment.
But I mean, we also read a bunch of text messages from the sergeant that were certainly not well received, absolutely racially charged, and so there is clear evidence in the record that raises an issue of a hostile work environment, right?
Right. Well, Your Honor, then I would point out that we made a statute of limitations argument with respect to all those comments and the emails. All of that took place in 2016 and 2017 during the time that the NFL protests were taking place.
Counsel, what about the sergeant's assertion that he has a constitutional right on whether or not to not like black people, right? There's racial animus behind that. And could a jury not find that?
Well,
you don't have to say that it is, but the question is, what could a jury find relating to that statement and the environment that it created?
But Your Honor, I respect the question, and I think that there is a constitutional right not to like different people of different races, and every person.
But making that pronouncement at your place of employment where you're working with all types of different people, a jury could find that creates a hostile environment.
Well, again, Your Honor, I just would point out that in the deposition, the plaintiff testified that Sergeant Toczek never made a racial slur, never directed racial comments at him.
Yeah, but a person can talk to the wall knowing that the plaintiff is there, and that.
I understand, Your Honor. Again, our position is that even taking Your Honor's point, it's a time-barred claim because the comments occurred prior to April of 2018.
No, but there's a single continuing pattern. This thing happened for a long time, and one of those comments was made in January 2019. But this was again, as I say, can be seen as a continuing pattern of conduct, because it was so similar.
Okay. All right, Your Honor.
And we are talking about a subordinate, right? So you're talking about, not liking and having a right not to like a person of a particular race, that just happens to be the subordinate to the person saying that.
You're correct, Your Honor. Martin Tocek is a sergeant, and the plaintiff is not is a police officer.
Thank you, counsel.
Okay, thank you.
I'd just like to add 2 small points. I'd like to emphasize the fact that the plaintiff has testified that this was ongoing for years, 2017 through 19. The comments continued.
What about your adversary's point that he never testified that any of this was directed towards him? How do you respond to that?
In a wonderful ruling that this court made, Hernandez v. Keisman, which was my case, I'm very proud of it, I'm sorry, 103 AD 3rd 106. In that case, Dr. Keisman was sending lewd emails all over the office, and they were received by men and women. But as this court astutely pointed out, well, women were being objectified, men weren't. So the comments were injurious, to the women, whether or not they were to the men. And this is exactly analogous in this case. So I just wanted to point that out. Other than that, unless you have a question for me, I have nothing to add.
Thank you, counsel. Thank you all.
Thank you.
Guzel v. King. Please.
Good afternoon. May it please the court, my name is Andreas Theodosiou. I represent the appellants in this action. This is an election case. Appellants are, at the time the action was commenced, members of the board of Inwood Towers. Inwood Towers is a Mitchell-Lama cooperative. An annual meeting was held on November 30th of 2023. Because a quorum didn't exist, the meeting was held open for an additional 60 days to permit any additional people who wish to vote to submit ballots. All ballots were submitted through an independent inspector of elections, Election Services United Corp. On the 30th day, which was January 29th, the inspector of elections determined that a quorum was reached. And
the quorum was reached through absentee ballots, I take it, right?
Absentee ballots, correct, yes. That a quorum was reached, and that as a result, they determined the winners of the election. They announced it on February 5th of 2024, and thereafter, after the announcement of the final results of the election, for which plaintiffs do not claim that they had no knowledge of the announcement, plaintiffs held a special meeting pursuant to BC.
Wait a second. When did they notice the special meeting?
They noticed the special meeting.
Before there was a certification.
Correct.
Right?
They noticed the special
so
meeting.
that's meaningful. It's not meaningful.
They noticed
so the
a
fact that
special
you
meeting.
didn't say it kind of leads me to believe that you're not seeing what's happening here.
Not at all. They noticed a special meeting a few days before the closure of the
And do their bylaws permit a special meeting?
The bylaws permit special meeting, but they noticed the special meeting not pursuant to the bylaws. They noticed a special meeting pursuant to BCL 603.
Well, let me ask you this. First of all, I think the non-profit. This is an HDFC.
It is an HDFC.
Right?
Well,
So
it's
the
not an HDFC. It's a Mitchell-Lama.
A Mitchell-Lama, I'm sorry. But so the not-for-profit law applies here, right? Not
the private housing finance law.
Right.
Yeah.
Not the BCL. But even if that's what they said, if it complies with the bylaws, does a special notice provision comply with the bylaws? Because sure, there's a statute, but you can regulate your own actions pursuant to bylaws. So my question is, did that notice comply with the bylaws?
The notice complied with the bylaws. The actual holding of the meeting did not comply with the bylaws.
Okay, so you have a notice of meeting before there's an announcement that a board has been forward. There's a notice of special meeting, which we agree complies with the bylaws of the corporation. And then there's a notification, well, this is the board, and then the special meeting is held. And it's your argument that the special meeting didn't comply with the bylaws.
Subsequent, I say this in my reply, subsequent to this motion, the plaintiffs moved for summary judgment, and we proved through summary judgment that they did not have the requisite signatures to hold that meeting. And that's why in their
And that
position...
motion was decided?
That motion was not decided, but they did not oppose that aspect of the motion, because they claimed that they had 50% or 50.001%.
So that's not resolved, but the meeting happens and the insurgent board says, we are now the board, right?
The insurgent board says we are now the board, but the
You've
insurgent
moved.
board says that they are now the board only under the theory that and the BCL has the same provision as...
Right, no, but we're
as
not
the
dealing with that
not-for-profit
right now.
cop.
We haven't gotten to the summary judgment motion. You're saying that they can't bring this as a plenary action.
Correct. I'm saying that what the proper way of having done it, because both the not-for-profit corporation law and the BCL both provide that that you can call a special meeting without, if there hadn't been an annual meeting in the 13 months prior.
But that's
But
not
there
right,
was
but
a
that's a
special
different
meeting.
thing than your board, your bylaws, which permit, you just told me, permit this to go.
But that's
And then all
not,
they're
but they
doing-
didn't proceed under the notice of meeting. They did not say that they are proceeding under the bylaws.
They did say there's a note on the notice, that it says, this meeting shall be held in accordance with the current bylaws of the Inwood Tower Incorporated as amended on May 21st. So is that possibly notice that they're invoking the bylaws and not
Now,
the
the notice of special meeting says this meeting is called pursuant to BCL 603. That is exactly what the notice of meeting says.
Okay, please continue.
And notice of meeting is on page 106.
No, I got it in front of me, counsel. It's okay. You have time in rebuttal. Thank you.
Thank you.
Good afternoon, Your Honors. My name is Peter Kerwin, and we represent the plaintiffs' appellants. I think it's important that we again review the timeline, which was one of Your Honors pointed out. They didn't have a meeting essentially for elections for 2 years, but for us, my clients sending the demand for a special meeting.
Right, in 2022, they weren't able to reach a quorum.
Correct. They went to Judge Lebovitz, as I recall, and Judge Lebovitz wrote in his decision, well, your remedy is to call for a special meeting. So they called the special meeting, whether it's under the Business Corporation Law, or under the not-for-profit law, or under the bylaws. The purposes of these provisions is to make sure that the board doesn't continue in power through chicanery.
And you're not challenging anything that the board did, right? You're
No.
just saying what we did. You want a declaration that
Right.
what we did was proper under our bylaws, and maybe it's not the BCL, because this is a Mitchell-Lama.
Non-for-profit law 604, which has a similar provision.
Yes.
Right.
And
So is that, do you have to bring that as an Article 78 or no?
no, because our clients moved to confirm their election. The only reason why they needed to do that is, as typical in these types of situations, the managing agent continues to follow the board that they've
So
been.
let me ask you this, even if their election was okay, you could have still, there's nothing wrong with you holding the special meeting. If it went properly, I'm not making any determination about that, and removing them and starting with a new board, right? If you had the number of shareholders.
Yes, we had the majority, for that particular election.
And that's what you're
right.
essentially seeking
Right,
declaration.
right,
that
we had the
regardless
major-
of whatever they did,
I
we're not challenging what they did. We're saying what we did was proper.
Yes, correct, because,
So essentially, you have to go forward.
right, the next step we passed the pre-answer motion to dismiss standard, and we have gone forward, and actually just got an alert that it's being reassigned to an.
Does it matter that there were other things done at this special meeting, other business that was raised? You also, I believe, reduced the number of board members and did one other thing. So was there authority to do more than just have the election at the special meeting?
From our viewpoint, once they controlled the majority at that election, they had the ballots or in person and proxy, and a majority approved those, then they can do so. And I just wanted to point out or
Is
conclude.
that what the bylaws say is permissible at a special meeting?
I believe the special meeting can be called, yes, but the argument that they were making was that the business, which by the way was in reply and not before the lower court, but the argument they were making is that pursuant to the business corporation law, they can only have a meeting of the directors. I don't necessarily agree with that, but because when you go through the mechanics of a meeting, and you're not supposed to do it by solely by proxy, which is the way the appellants say you do. They're supposed to, if they don't have a quorum, they're supposed to schedule a new meeting, like a special meeting. The people come together to vote either in person or a proxy. You can't do what they did.
But I mean, you're not challenging that.
No, we're
in
not
this
challenging
lawsuit,
that.
right? Because that might have been a different thing.
Right, we're not challenging that. Once our clients submitted the demand for a special meeting or special election, however you want to phrase it, they were required to call it. And they didn't. Instead, in reaction to that, they claimed that suddenly they have all these ballots, and therefore our election is incorrect. And taking their position to the logical conclusion, as the law requires, they cannot challenge our result because they didn't do an Article 78. So that's why we move for a declaratory judgment, to confirm our election by a majority. Thank you.
Thank you, Councilman.
Oh.
Your Honors, even the demand for a special meeting cites 603. Nowhere does it cite any provision of the bylaws. And the demand for a meeting is...
It does mention the bylaws, though, Council. We both have it in front of us. It does say, note that this, whatever it says about it, I read it to you already. This meeting shall be held in accordance with the current bylaws. It doesn't quote any particular bylaw, but you see where it says note just above the date? It says that.
The notice of special, the demand for a special meeting?
Yeah, notice a special meeting. I'm on record 107. Am I on the wrong page?
The demand for a special meeting is on page 96.
See, that's the demand, but the notice does say, there's a note there. I mean, it says it, so it's okay. You can keep.
But I mean, is that what your Article 78? I don't think your Article 78 argument turns on that at
our
all.
argument-
So I'm not really sure why you're stuck on it.
Our argument is that because the BCL or the not-for-profit law both apply only if there hasn't been an election, a duly held election in the 13 months prior, then you can invoke those sections to call a special meeting.
And you're saying that that's not a Scrivener's error, because even though they're entitled to do it under their own bylaws, and the bylaws are mentioned in the they're not challenging your election, they're challenging your refusal to accept their special meeting. That is a plenary action. It's not an Article 78.
Our position is that it is an Article 78 only because they are in fact challenging the election, because they're not proceeding under the bylaws, but they were explicitly proceeding under the sections of the law that they noticed, both in their demand and in their notice of meeting.
Thank you, Council. Thank you both. Finally, Tapanakis v. Pace University.
Good afternoon. May it please the court. My name is Peter Katzman from Maria Schwartz Bradham. On behalf of plaintiff appellant, I'd like to introduce my co-counsel, Andre Belange, and request that he be permitted to participate in this appeal.
Granted.
Thank you.
Let me reset the clock for you, counsel.
May it please the court, Andre Belanger on behalf of plaintiff appellant. This case is pretty narrow, but it's an important point. Plaintiff and thousands of other students prepaid money for mandatory fees associated with on-campus activities that were not related to any particular academic program or class.
Can you agree with us that we're dealing with the same plaintiff, the same issue, the same interpretation of the emergency closing provisions that everyone was on notice of?
I'm sorry, Your Honor, could
That
you?
we're dealing with the same emergency closing provision that was in the bulletins, et cetera, et cetera.
We are.
Really, and can we agree that there was a full and fair opportunity to litigate the interpretation of the emergency closing provisions as to whether it would preclude or help in this litigation?
I would not agree with the second part of Your Honor's premise. There was a Second Circuit.
Well, that's my
case.
point. See, Goldberg, there was, and your client eventually was substituted, but the federal action fully addressed de novo the emergency closing provision here, correct?
As it pertains.
And it applied New York law in its analysis, correct?
As it pertains to a claim made for refund of tuition. So if I could get to the Goldberg decision, Goldberg is a different plaintiff than our plaintiff here. That case we're dealing with.
It's the same closing provision, right? The same emergency.
Correct, and we look at the emergency provision as having two components. One is a general, in case of an emergency, we can close classes, and then at the very, very end, it mentions that, we have,
But I mean, below, you sought both, in this claim, the case, you also sought return of tuition, correct?
we did seek
Even
return
though
of
that
tuition.
had been resolved in the Goldberg action.
So when we went up at the Second Circuit, that addressed just the refund of tuition.
And then you brought this case seeking refund of tuition, the exact same claim, right?
The claim that's
And
before-
more. But I'm saying that, but I think what you've read, I mean, we've read your complaint. You sought the tuition.
But the claim that.
And you sought the extra fees.
Right, and that's the only thing that's.
Okay, so right, on appeal, we're just talking about you've accepted that Goldberg, or you've accepted the reasoning of Goldberg with respect to the tuition, at least you haven't appealed it.
Yes.
So now we're just talking about the special fees, right?
Correct.
And what is it that makes the special fees different from the tuition?
That's a great question, and the answer is that these are 4 mandatory fees that are not tied to any specific academic class. So when you have the emergency clause that allows PACE to do what it did and says that you do not have to refund the tuition, well, implicit in that you have that any fees associated with those classes would not have to be refunded. But here we're talking about a specific subset of fees that I do not believe was addressed within that provision. And
But what makes the fees different?
Pardon?
What makes those fees different in terms of the analysis utilized in Goldberg?
Because we're dealing with the very, very last portion of the clause that talks about in the event that your classes have to be rescheduled or you have a different continuation date, we're not going to be responsible for the refund of tuition and fees. We're not asking for class-related fees. We are asking for the return of fees for on-campus services and activities that were prepaid in advance, where our clients were never given the opportunity to fully participate in those because the school shut down. Okay, and these are like the mandatory fee deals with things such as inter-campus transportation, which won't exist when your campus is closed down. They'll deal with things such as security, which you will not need if you are at home. There are components within the fees which I think the lower court on their original summary judgment motion said was a good issue of material fact to deny summary judgment that are still outstanding. And I'll rest with this, just asking that we interpret the contractual provisions narrowly as possible, and I'll save the rest of my comments on that for rebuttal because I do see I have the red light, Your Honor.
Thank you.
Good afternoon. May it please the court. Suzanne Messer, Bond, Shenick & King, on behalf of Pace University. I'd like to point the court to the issues presented in this case, which are limited to whether the emergency closings provision acted as a force
what I
majeure.
hear your adversary saying is that there's these very trying to parse through the fees, right? That there are fees dealing with things that could only occur if the campus was open, and that's what makes this different from the analysis in Goldberg. How do you address that?
So there is no difference, Your Honor. The emergency closings provision is set forth in the supplemental record, page 77. It's also set forth on page 15 of Pace's brief in this case. And it makes no distinction. In fact, what it says is, the university shall not be responsible for the refund of any tuition or fees in the event of any such occurrence. And the occurrence that's being referenced there are when the university is confronted by the need to close because of inclement weather or other reasons beyond the university's control. This is a force majeure clause. It identifies a triggering event, reasons beyond the university's control, and then it allocates the economic consequences of that risk. That is, by definition, a force majeure clause. Now, with respect to the Goldberg case, that case did involve a separate plaintiff. However, it was persuasive authority that the Supreme Court admitted Justice Adams admitted she did not discuss it in her decision on summary judgment. This is exactly what CPLR 2221D2 is intended to address. When Pace raised that issue and said, you've got this really persuasive authority addressing exactly the emergency closing provision at issue in this case, and you didn't meaningfully engage with that, Justice Adams. She looked at that and in her discretion said, you know what, you're right. And so she granted re-argument, reconsidered that language, and came out with the correct conclusion. That is exactly what re-argument is meant to be. Appellant in their brief talks about the Reinasco case, they talk about the Meng versus New School case, and they talk about the Barnard case. Those were all Second Circuit cases in which the court addressed broad disclaimers, not force majeure clauses. And that's all set forth fairly in detail in our brief.
In Goldberg, the Second Circuit makes clear to distinguish the facts in Goldberg from Reneko and the other cases.
That's true, and also—
Parsing the very language in Pace's bulletins.
That's exactly correct. And also in the companion case here, which is the Tapanakis versus Pace University Second Circuit decision, that case involved the breach of contract claim relating to tuition that Your Honor was discussing with my opponent here. And in that case, the court said Pace did not, the breach of implied contract claim relating to tuition could not go forward because of the emergency closings provision. So you have the Goldberg case saying that's a force majeure clause, and then you have the Tapanakis decision.
But I think that the nuance here, I think, is counsel is saying, sure, okay, that the force majeure clause only covers tuition and not fees. Why do you respond to that?
The clause itself includes any tuition or fees.
So, I mean, we can see that there's a distinction between what fees, you know, listening to counsel, fees take care of buses or security, which you don't need when you're not there. Tuition, you could still have classes and paying teachers and stuff, which we all did online for months and all our life. So even though it's both together, should they be analyzed differently?
Not in this case, Your Honor, because the issue is whether this emergency closings provision, which explicitly deals with both tuition and fees, should bar a breach of contract claim. The Second Circuit has said that it does. That's res judicata. And the Goldberg decision is also very persuasive authority. So we'd ask that the Supreme Court's decision be affirmed.
Thank you, counsel.
Your Honors, in my brief rebuttal, I'd like to also point out that in the Goldberg case that we have been talking about, the claim for fees was abandoned, I presume to bring the case forward through the appellate process, so that was not addressed. And in the Second Circuit case dealing with our client in this university, the opinion does not address the mandatory fees at issue here. So I'm not suggesting.
But when the force majeure says fees, why shouldn't we take it to mean what it says?
Because I'd like to look at the entirety of the provision and where that section comes down and read contracts favorably in light of the plaintiff and interpret these very, very narrow. Our reading of that provision dealing with just fees is tying those fees that were to classes that were having
It
to be
doesn't say that, right? It doesn't say only those fees that are tied to classes. It says fees.
It does not, but we did
You
not.
would like
draft the
us to
provision.
interpret it that way, that's what you would like us to see.
I'm trying to interpret
And when
as
we
narrow
get
as
your
possible.
distinction in what you said, I'm not sure we can interpret it that way, but I think that's what you're saying, right?
Yes, Your Honor.
Thank you, counsel. Thank you all.
Hey, thank y'all very much. I'm not from here. I appreciate you letting me pro hockey.
Enjoy New York
You're
City.
not from here?
Thank
you for listening.
Thank y'all.
We can't adjourn without telling you, if you're going to go to Katz's Delicatessen, don't go on a weekend.
Okay, thank you. Meeting you. Thank you very much for everything. Thank you. Appreciate y'all.